It's not a 5,000. So, there is no representation. There is no representation on behalf of the petitioner. Well, even counsel for the petitioner is not present. The office note that the amount of 5,000 as directed by this court by order dated 6/4/2024 has not been deposited in the Orissa High Court, the account of Orissa High Court Legal Services Committee. Stop. List this matter on 8 weeks. When the court will consider passing appropriate orders. TR has ordered for listing. When did you file your appeal?
Appeal was filed on 12th July.
It will be taken up. Why are you going to DR?
My lord, if your lordship permits me,
Yeah.
in fact, I do not know whether that authority is still continuing. Usually, we make a mention, file the mention report.
That is different.
That has been produced possibly for your lordship for permission to list.
That is
At
different.
times, we mention for the honorable court directly, and at times before the land DR, we file the memo, maybe which your lordship said. That is what he wants to say. May I be just pardon to make a mention? A matrimonial appeal was disposed of by my Lord Justice S. Talapatra and my Lord Justice Savitri Rathod. Now, in that matrimonial appeal, another lady has filed a petition for recalling the same, claiming to be the wife. Because of pendings of this, the wife is not getting any pension and other benefits. I pray this can be listed for this.
This you could have given to DR. All right.
Because
And then
You would have brought it.
because this requires constitution of a bench.
I think it can be your lordship because my Lord Justice Rathod is there.
Just this is the system which I am following. That all such matters which are to be listed before break benches, all those matters are being listed on Fridays. So you just.
Well, that file has to come and then it will be listed.
I'm obliged.
So you give it before the
I'll
deputation.
That will happen, don't worry.
My lord, I may kindly pardon to make a mention, my lord. Item number 24, my lord. That batch of matter, my lord. In this WPC number 18,342 of 24 has been wrongly tagged, my lord. That may be separated.
Let the matter be called. All right.
I may pardon my lord, item 8.
Out of list mentions over. Out of list mentions over.
I have a letter of person anybody, my lord. Forward matter. In the after notice matter, your lordship has directed the BDA to obtain instruction. I have filed several memos on the idea that is not listed, my lord.
Why are you filing this? This is division bench matter?
Yes,
Or
my lord, division.
you are not getting your pension?
Writ appeal, writ appeal, writ appeal.
Yes. Writ
Petition, why the matter has come before the
Pension.
division bench?
This is my lord,
Pension comes.
Why are you saying pension?
the BDA, the employee association.
No, perhaps he is not. Yeah, challenge the virus of a rule.
Why is this difficult?
So no, in that case, what I have remembered, if similar judgment has been passed, that extending the benefit to that their urban, perhaps
5860?
Oh, no, their development agency. So in that virus that has been passed, and your lordship has said that they are entitled to that benefit of pension. Bhubaneswar, that is the Bhubaneswar Development Authority in case.
The lordship delivered a judgment in case of Mr. Mahapatra who was arguing, I think, lords. The lordship has already delivered a judgment.
Not my lord's judgment. The justice, the lord judgment of Justice Saudagi. So perhaps he wants to be covered by that judgment, and he's saying that writ appeal, that perhaps that is not a writ appeal.
Not a written.
But why the matter has been listed before the division bench? Why do we want the matter to be listed before division bench? Oh, virus.
Well, this also virus has been challenged. This has not been declared.
He also challenges, so he's submitting in a wrong manner that with,
Previously, we will see.
May I pardon, my lord? I may pardon, my lord. So, I may make it mention. It's a tender matter, my lord. Place tender has been invited.
First tender?
Has been invited for, that's why. For the self same work, press tender has been invited, where the petitioner was L1 before, for the self same work.
May I please item 48, no instruction.
Instructions 48.
Item number 4, sir.
Just, what happens?
Number 20 for today's supplementary your lordship. This is the covered matter, the college matter, nothing matter, your lordship. The covered matter, deleted case, they have issued the NOC. That matter already your lordship has adjudicated that matter, this is the covered matter. Item
Over.
20 for WBC number 1.
You want to withdraw? Do you want to withdraw?
No, madam, this is the covered matter, according to your lordship, kindly dispose of that.
That will be disposed of when the matter is filed. When the matter is filed, we will dispose it of.
Madam, like,
Is it in the list?
madam,
Is it in the list?
yes, yes.
Oh, then.
That's the showing the orders. Yes,
Item number 4.
Yes, madam. Madam, the collector is on the.
That matter lordship wanted the collector Nayagur to give a status report also, lords. Lords, this is the report submitted by her, lords.
yes, whether the collector has joined.
Yes, but she had joined, lords.
What is the status?
The public interest litigation.
My lord, for a minimum facilities to the
Just a
villages.
minute.
She has already joined, lords.
Sir, I'm present, sir.
So this is this the situation everywhere in other districts or is it peculiar to Nayagarh?
Because it's in respect of Gonia block only. One block she has given the details and now.
Please, Mr. Counsel,
Yes, madam.
In the district of Nayagarh.
never do it.
Sorry.
So far as district is concerned, she has given the details of the Nayagarh district only, lords. If a lordship will be kind enough to lords give a direction that I will give the details of in respect 30 districts. Lords, either the revenue department or lords, I can file an affidavit. But this is only in respect of Nayagarh district, lords.
How can we think of villages without electricity?
Roads also.
There is no electricity.
Madam, how do the children read in the evening if there is no electricity?
Sir, with due permission, sir, I'd like to submit here that, sir, the first issue here is that a lot of these villages, sir, one issue is the electricity connection going to the village. The second issue is electricity connection going to a particular household. So, because household addition to any village, and these are typically hamlet villages, these are not our unit for administration is typically GP, sir, Gram Panchayat level. So there are very few GPs which will have no electricity connection to the GP itself. But the hamlet villages and the households, sir, because these are a constant addition to any hamlet or to a village. So there are times when they are left out from electrification. We have been doing periodic surveys are done every year almost to identify any unelectrified household or any unelectrified hamlet village in any panchayat also. And to that effect, that survey has been done last year, sir. And the state OPTCL, sir, which does the transmission, is in the process of electrification of unelectrified villages in the state. This I speak from the experience of my previous district postings also, sir. But the household connection, sir, if electrical connectivity has come to my village, but my household does not have connection, that is typically because it is my responsibility to go and provide a connection with a meter and everything for my household. But because these are remote areas, we are also taking up steps to create awareness among people and get this done also in a mission mode, sir.
Madam, GP, sometimes you're talking of the Gram Panchayat. So where the Gram Panchayat is situated, it is sometimes far away from some of the villages. The number
Yes,
of
ma'am.
villages are covered, some might be far away. And what you have said that these hamlets are new, how many households are there? Understand if there are 10 houses in the new hamlet or something not covered. Suppose there are more, then it is a problem. How will the children study?
Ma'am, that is correct, ma'am. So, ma'am, for these three villages for which the PIL has been filed, we have given a status of the households, the number of households also, madam.
Which
Ma'am, annexure 1, ma'am.
yes.
So this is the household position, ma'am, in these three hamlet villages. Musiguda.
For example,
So, for example, in Musiguda village, there are total 6 households, sir.
Just one moment. Musiguda. Where is Musiguda?
First, minutes, name of the block, second column, extent of basic facilities, Musiguda village, minutes.
Yes. So Musiguda. All right. Total number of households 6. Okay. So Musiguda village has only 6 households.
Yes, madam.
So that includes 5 kacha houses and 1 pakka house already. Then there is one Salapalli. All right. So this is. So Musiguda has 6 and Salapkanda has 8.
And
Yes, madam.
and
Yes.
Sandipalli, 25, minutes.
Where is 25? Sadhuapalli.
Sadhuapalli, 25, minutes.
Okay, okay. There, they are larger number. There is considerable. Drinking water supply, 1 borewell is there.
How do you define village, madam? How do you define a village?
Sir, these are smaller hamlets, sir. Typically, depending upon the government department that whose scheme we are referring to, sir, the basic unit might be different. So for PR department schemes, which are typically these schemes referred to here, sir, Pradhan Mantri Awas drinking water supply, the unit is Gram Panchayat. But a Gram Panchayat will typically be made of several revenue villages, 10 to 15 revenue villages at least together, sir, which will have their own different map.
You have a village, you are calling it a village, Musiguda, having 6 number of households, and the nearest school is 18 kilometers away from that village. And
That's right.
and a student of that village is enrolled in the nearest school.
That is right, sir. Sir, the school that is nearest to that village is a high school, sir. It's a upgraded government high school, sir. Badasilinga upgraded government high school. We actually checked, sir. The reason for this was that the number of households being small, sir, there is no high school level student in these households. They are actually going to an upper primary school also situated in the Badasilinga GP, sir. These all Musiguda and Salapganda come under Badasilinga GP, sir. Sir, actually, the availability of schools is also a little bit dependent on the ability to have sufficient number of students in its catchment area, so to speak. So, having a school only for 10 households will be prohibitively expensive.
How many such or the villages are there, like Musiguda, near Musiguda?
Sorry, with a household strength less than 10.
Like less than 10, like say this is Musiguda, which is the nearest village?
The Salapganda is the nearest village to this. So these two villages are together, sir. Quite nearby, within 2 kilometers of each other, sir.
No, within the 2 kilometers, see. A student of Salapganda village are enrolled at nearest school, which is 15 kilometers.
Sir.
Village with 2 blocks, one Gonia block and one Kontapada block. That means Gonia block, these are the only 2 villages which have these problems of electricity and schools, or that you have to find out.
No, ma'am. I am afraid there would be more villages definitely, where there would be unelectrified hamlets, where there would be drinking water issues, where only groundwater drinking water like tube well in this case is available. Gania block is also a heavily forested block, ma'am.
Oh, but how will the tube well function if you don't have electricity?
Sir, it's that
Pump.
hand
Pump.
And pump.
But another thing, it has to be ensured that those tube wells are working. Sometimes.
Sir, ma'am, that we have checked, ma'am. Tube wells are functioning, but the attempt is to provide them surface water connectivity through pipe water, ma'am. That project is also ongoing.
Detail affidavit will be filed, lots.
What's the name?
Name I've given, the last occasion I've given the name in the order sheet is there.
It's court's order dated 21/7/2024. Compliance report has been filed by London AGA. appearing on behalf of the opposite parties, as supplied to him by the district magistrate. Which district?
Nayagarh.
Niagara.
Nayagarh.
No, I got it.
Stop. The district magistrate, Niagara, has joined the proceeding online. Stop. In the status report submitted today, following has been mentioned. It has been disclosed that in the district of Niagara, out of 1,672 villages, only 107 villages are not having all wells, and 247 villages are not having mobile connectivity. So stop. All villages are having tube-well drinking water facility and mega, what is PWS?
Sir, pipe water supply.
Pipe water supply scheme will also cover them shortly. So stop. She has also disclosed that 1,443 number of villages in Niagara district have electricity supply. Stop. Apparently, thus, there are 229 villages in the said district which do not have the electricity supply. We'll stop. Next. Let a detailed counter affidavit be filed on behalf of the district magistrate Niagara, stating the steps which the state government, stating the scheme for electrification of the villages and the steps which have been taken and are likely to be taken for electrifying electrification of the villages. So stop. Next. We also expect, who is the which department will be dealing with everything?
Yeah.
Yes,
Gram Panchayat.
yes,
Panchayati Raj and drinking water.
We also expect the additional chief secretary Panchayat Raj.
Yes, Principal Secretary Panchayati.
Principal Secretary.
Principal Secretary Panchayat Raj to file an affidavit disclosing the status of electrification of the villages in the state of Odisha, supply of drinking water to such villages and supply of drinking water to such villages coupled with the availability of schools nearby the such villages, nearby the villages. Pointing out the deficiencies within. List this matter on 6 weeks. In the meanwhile, madam, you should do whatever you can.
Personal opinion.
Personal appearance of district magistrate stands dispensed with.
Item number 1.
May I please, Your Lordship?
Yes,
With Your Lordship's kind permission, I'm filing a dead check for convenience, my lord. Maybe I'll just place the dead chat and thereafter I'll assist to Lordship with reference to the annexes.
no, why has this come before division bench? Are you challenging an order of the tribunal?
My lord. And challenging an order of the tribunal, here the writ petition was dismissed. Here the petition was dismissed. The restoration application was filed belatedly. That was not entertained. Matter was carried to the Honorable Appeals Court. Honorable Appeals Court taking note of the fact that similar employee the writ petition was allowed and the SLP against that was dismissed, which I have given in my additional affidavit, was pleased to restore the writ petition instead of only dealing with the condonation matter and send the matter back for reconciliation of reasonable court. And that is how the matter has come up before Your Lordship. There is one mistake with regard to the Annexure 2. I will point out that. But before that, may I just, with Your Lordship's permission, state, my lord, for Your Lordship's appreciation. And on 30/12/99, in fact, this petitioner and others were appointed as NMRs. Under Annexure 1 to the writ petition, a policy was brought into picture for regularizing them. And this is what 30/12/2019.
What is NMR?
That is, my lord, nominal muster roll employees. They are not regular employees. And this Annexure 1 resolution was brought into picture for the purpose of regularizing those NMRs in a schematic manner. And 30/12/99 was the regularization order passed in respect of the petitioner. Observing him as a mate, my lord, that is what was, my lord, 30/12/99. Then, my lord, the petitioner joined on 1/1/2000. 27/1/2000 appointment order of
That
the
should not be MAT, that should be METH, mate.
my lord, that is what it is spelled, my lord. My lord, that is how I have mentioned it like that. My lord.
All right.
I'll stand corrected with reference to the document. My 27/1/2000, the appointment order of the petitioner was cancelled by the order number 483, Annex 3. But 2012-2001, the petitioner moved the Administrative Tribunal Bhubaneswar Bench, Bhubaneswar, by OA number so-and-so. OA was dismissed. 15/1/2007, the Office of Opposite Party number 2 called upon the Opposite Party number 4 to attend its office with record for discussion, observing that the appointment of the petitioner, another G.K. Padhi, in the regular wages post of not been cancelled. But though the order of cancellation was challenged, the authorities themselves says that it has not been cancelled. Then, my lord, 24/5/2007, the Opposite Party number 1 clarified that the post of Mate has not been cancelled. 28/8/2008, the Office of Opposite Party number 1, in its letter to the Opposite Party number 4, clarified that in view of the order of status quo passed in the above writ petition, the continuance of the petitioner in the post of NMR without cancellation of order of appointment to the post of Mate wages is irregular and in violation of order dated 12/8/2002 passed by reasonable court. The Opposite Party number 4 was requested to act upon the instruction and report compliance within a week. 2010-2008, in pursuance of letter dated 28/8/2008, the Opposite Party number 4, by order memo number 6936, allowed the petitioner to continue as mate under regular wages establishment with retrospective effect from 27/1/2000. That is the date the petitioner was reverted to NMR, and his service is treated to be continuous with effect from 1/1/2000. That is his initial date of joining on the aforesaid post, which is subject to final outcome of the above writ petition. Then, those letters were issued by the competent authorities, which reveals that the service of the petitioner is very much required. That is Annexure 6 series. 24/12/2019, the writ petition was dismissed. Petitioner was reverted to the former post, that is NMR typist. 12/2/2024, the petitioner moved before the Honorable Supreme Court of India by the SLP number so and so. The Honorable Supreme Court of India was pleased to register the writ petition to file, taking note of the fact that in identical matter, this Honorable Court granted relief in favor of other employee and specially petition against such order was dismissed. Well, then I have quoted Gopal Krishna Pari case because that is similar to this case. So allowed by this Honorable Court, the state carried appeal before the Honorable Appeals Court that has been dismissed, which I have also annexed for your Lordship's reference. Now, my Lord, your Lordship will kindly see. My Lord, Annexure 1. Annexure 1 to the writ petition that is at page my Lord, 14, that is the resolution of the year 97, which they brought into picture for the purpose of regularization of these NMR employees. On the basis of that, I was regularized as a fourth batch. Now they were regularizing in batch wise. I was regularized in the fourth batch. But unfortunately, my Lord, I cannot improve upon it for the time being, my Lord, and I have to do it by way of amendment. Annexure 2, which is given with regard to his regularization, pertains to the third batch, not the fourth batch. He was regularized in the fourth batch. Then subsequently, Annexure 3 came into existence, purportedly cancelling those regularization. That is what was challenged in the before the Orissa Administrative Tribunal. The OA got dismissed, writ petition was filed, interim protection was granted. Because before the tribunal also interim protection was there. I continued. But then unfortunately the writ petition got dismissed, restoration application was rejected. When it was rejected, my Lord, I was reverted back. I carried the matter to the Honorable Supreme Court. Now the Honorable Supreme Court has been pleased to observe that my case is similar to other case which has been done, which has been allowed by this Honorable Court.
No,
Which
where
are-
is that finding of
My Lord?
Supreme Court? Where is the finding of Supreme Court?
My Lord, your Lordship will your Honorable Supreme Court has taken note of that. That I beg to place from
Taken
page.
note of, might have taken note of your points then, but. is
Not
there any
finding.
observation?
I'll not say it's a finding.
This is what we are saying.
It's only a taking note of the submission that similar
This
cases.
is different.
Much obliged, fact. I beg to draw your Lordship certain kind attention to page 64, the case of the page 65, the case of the other employee, which I am for the purpose of my case also, wherein the SLP file also has been dismissed. Your Lordship will kindly find that at page 65.
What?
That is the case of Gopal Krishna Padi.
All right.
And apart from that, your Lordship will also see the letters of the authorities which I have given in my affidavit. That is, my Lord, your Lordship will peruse page 51, Annexure 5 series.
Yes.
Now, here I beg to point out what was challenged for the land tribunal was Annexure 3 to the writ petition, that is the order cancelling the regularization of the petition to the post of mate. Now, the authority says on 15/1/2007, where the cancellation took place on 27th of January 2000. Now, on 15/1/2007, the authority says that, in fact, so far as my appointment is concerned, I am placing it, my Lord, I am directed to state that the examination of materials of the above cases reveals that appointments of Sri Upendra Bisoi and Sri G.K. Padi made in regular wages post of mate have been cancelled as far as your office order number 27/1/2000 are concerned. You are therefore requested to personally attend this office along with the records for discussion with the legal cell of this office as early as possible. Then, post facto that, again another letter on 24th of May 2007 was issued by the superintending engineer saying like this: in continuation to office letter cited above, after scrutiny of this office cancellation order number so and so dated 27/1/2000 and order number 4119 dated 7/8/2000 on the provisional appointment order number 6761 dated 30/12/99 of this office, it is ascertained that the post of Khalasi have been cancelled, but not the post of mate, as observed from the available documents. The said clarification under reference number 2 was intended for cancellation of both the posts, that is mate and Khalasi, but the orders made are unfortunately contradictory. This is favor of kind information and necessary action. Then, subsequent to that, again, my Lord, by letter dated 28/8/2008, the Deputy Secretary of Government writes to the Superintending Engineer, and this letter I beg to, my lord, place, this is one page in extenso for your lordship's kind appreciation. I am directed to
So you have
invite,
to establish your right one.
these are all documents I am establishing my right, not depending on that Gopal Krishna Padi. But what I beg to point out to your lordship, in these letters, a reference to both Gopal Krishna Padi and the petitioner is being made. Gopal case has been allowed, confirmed in Honorable Appeals Court. In these letters, your lordship has been pleased to notice the first letter, that is 15/1/2007, wherein it was clarified by the authority.
Gopal Krishna Padi case was allowed by the tribunal,
No, by this noble court.
by this court.
Yes. And specially petition was carried by the state government. That was dismissed by the Honorable Appeals Court. That I have annexed also. The authorities post facto the so-called cancellation order in the year 2000, in 2007 clarifies that in post of the present petitioner and Gopal Krishna Padi was never cancelled. That is what the authority says. And after issuance of series of letters, I was again brought back to the post of Mate, but the order of status quo of this noble court was in force then, but the writ petition was pending. And they said, if you don't do it, this will be in violation of the order of the honorable court. And that is how I was restored to the position. Despite the authorities clarifying that the 2000 order never cancelled my appointment to the post of Mate, post facto the dismissal of the writ petition and rejection of the restoration application, my lord, they have again taken me back. But they have contradicted themselves. You on one hand in 2007-8 say that no, my post has not been cancelled. Then if it has not been cancelled, without issuing a further cancellation
So
letter.
you were reverted because of dismissal of the writ petition.
Much obliged, my lord. That is what I have furnished in the jet chat. So when you say 2000 order was not a cancellation order applicable to either Gopal Krishna Padi or me, then you could not have reverted back me in the absence of a fresh order justifying the same. Rather, their documents which I have annexed in the additional affidavit your lordship will see, they say those of Mate are now manned by people, they need 6 posts. That is what they have said. That means the post is available, and in terms of the resolution order annexure 1 to the writ petition, the regularization is permissible, there is nothing illegal in it. That your lordship will kindly find at page.
No, but when was your writ application dismissed for default?
Writ application was dismissed.
Restoration petition
Ma'am,
dismissed on the ground of limitation when?
I just. That is 19, that is 24/12/2019.
2019.
Mile.
That was the writ petition was dismissed. Your restoration, when was it dismissed?
In fact, the SLP that was carried was against the order date 2019.
No, it is,
Writ petition or
27.
dismissed? No, writ petition was dismissed on 19/4/2019. Writ petition was dismissed for default. 19/4/2019.
19/4.
Yes, ma'am.
That is, was that no instruction, that one?
Yes, perhaps.
So up to 2019, he was working.
He was working by virtue of that interim order. After dismissal of your lordship, on last occasion, the lordship has directed my instruction. After dismissal of the writ petition, he was allowed to continue on NMR basis.
Yes. So what is your age?
But now I'll be retiring in 2027.
Have you given your date of birth?
My date of birth, your lordship, I have not
Give your
mentioned.
date of birth.
But in my affidavit, I have said it.
So many things will depend on that also. You must.
Your lordship will kindly see page 47. Page 47, paragraph 3. The petitioner is due to retire from his service on 31/1.
That we don't know. You will have to give something.
I have to give. I have to be.
This matter on one week retaining its position. First off, considering the uh, developments subsequent to filing of the writ petition in 2022, 2002, which has remained pending for one reason or the other, comma, in the background of the relief is the petitioner is seeking, comma, let an affidavit be filed disclosing the date of birth of the petitioner with supporting documents.
Apply.
Item number 2.
The direction of your lordship on 30th. We have complied with your memo. Already the receipt memo. He has received the money 7,96,350. Kindly have a glance. Check we received banker's check notes so and so from the branch manager, and also unlike it was also encashed in her account after receiving from him. The photograph is also filed with the branch manager personally went to her and saw the check.
Happy?
I am
not there.
Please for the nominal.
Respondent 2.
So will you release the money?
That is the document.
Will you release the rest of the amount? Which you have,
Money.
there is no representation on behalf of the applicant. Slash petitioner. First off. When counsel appearing on behalf of the bank and opposite party respond number
1,
2.
sorry, you are for respondent number 2.
Yes.
respond number 2 are present. Respond number 2 bracketed the appellant's nominee of the bank account number. Right? First off, a total sum of rupees 9 lakh.
7 lakhs.
So what was the total amount?
Total 1 million. Total money was 9,46,350.
Was lying in the account of the deceased account holder. So stop. It appears that some dispute had emerged between the nominee and the legal heir of the deceased account holder. And initially, before the learned single judge at the 1,50,000 and the rest, the amount shall be paid to the husband
7,96,350.
to the wife of the account holder, bracketed, being the legal heir. Stop. Learned counsel representing the bank has informed this court that a sum of rupees 7,96,350 has been paid to the appellant through banker's check. Stop. Next. Learned counsel appearing on behalf of the nominee based on instructions has submitted that that the nominee shall not retain the amount, rather he shall be paying the amount to stop. Next. In such view of the matter, the application, the WH commission and disposed of. They have reached a compromise. Yes, sir.
Item number 3.
This UNTR,
It's so much of by your lordship's registry mills.
Yes. Yes. What is this?
Sir, lordship, give a copy. I will
have it.
Yes.
Sir Rautray, can we appoint you as amicus in this case?
Yes.
This is a case where a judicial officer has been threatened by a police officer. So, it's a very serious matter.
Right. Plus, if I get an order from notice of this case, you can also write to the authorities to initiate proceedings against him, also an inquiry into the matter.
Might have done that.
I'll take an instruction also, Milos.
Criminal contempt CD. Criminal contempt case has been registered after having taken suo motu notice of the fact, suo motu notice of the allegation in the letter of MS Mandira Mahanta, letter of JMFC, Judicial Magistrate First Class, Barpali, who intimated that, who had intimated to the Superintendent of Police and the Superintendent of Police that SI, that a Sub-Inspector of Police, Devananda Malik of Barapali PS, Barpali PS was not submitting up-to-date case diary and other relevant documents. So stop. He had telephoned the husband of the judicial officer, issuing threats. Soon after the information was received, the Superintendent of Police was informed by the district judge in this regard. for providing necessary security to the magistrate in the court and her residence. Full stop. Next. Mr. AGA. When council has accepted notice on behalf of the state. Full stop. On our request, Mr. BP Rautrai and senior counsel has agreed to assess this court as an amicus curiae in this matter. Issue notice who shall be required to be through the Director General of Police. Stop. The contemner shall be required to be personally present in court on 2 weeks. Let the relevant records be supplied to learned AGA and Mr. Rautrai and senior counsel in course of the day by the registry.
Item number 5.
I was addressing yourself. WPC 8166 of 2024. I have made a compilation of the rules. Though Mr. Mohanty had placed certain parts of the rules, but I have made the compilation of different rules which will be some relevancy so far the case is concerned, because I was addressing, also recollect, Article 321. Article 323. So far 323 is concerned, the consultation, the division bench in the earlier division bench has given some finding. But now I am addressing Article 321. So in order to take your lordship to Article 321, that before, you also look to the rules. I have a relevant portion of the rules. Now, this is at page 1. I have page marked also for your lordship's convenience. This is called, these rules may be called Orissa Civil Service Criteria for Selection for Appointment, including Promotion Rules 2003. Let's get it. A, commission means original. Then C, service means state civil service. Service means state civil service. Then rule 3, initial recruitment. The commission oblique Orissa Staff Selection Commission. Commission has been defined as Orissa Public Service Commission. We are concerned with the Orissa Public Service Commission, or the appointing authority in case where such bodies do not exist or do not exercise their jurisdiction, shall, for the purpose of initial appointment to any service oblique post, prepare a list through competitive examination containing the names of successful candidate, 1 is equal to 10 times the number of vacancy anticipated pertaining to that year, provided in case where the list contains less number of successful candidates than the vacancy anticipated, the reason for such shortfall shall be recorded in writing. Then we also look to the Rule 5, the non-obstantive clause Rule 2, space 2, Rule 5, overriding effect. The provision of these rules shall have overriding effect, notwithstanding anything to the contrary contained in any other recruitment rule. Let's get it at page 2.
Page 2.
Yes. The rule that is at page 1, I'm taking to lordship to page 2 of that rule.
Yeah, but you are reading page
I was reading page 1. I'm just taking to Lordship again. Sorry,
Yes, overriding.
override.
Yes.
Rule 3, initial recruitment. Initial recruitment, prepare a list through competitive examination. And overriding effect is the provision of these rules shall have overriding effect notwithstanding anything to the contrary contained in any other recruitment rule for the timing in force. That's the kindly back. Then you also kindly come to the page 3. That is 2012 rule, our rule, the present. This is the original rule in 2012. If you also will look to rule 6, of course, Mr. Mahanti had referred to that, page 5, rule 6. Eligibility criteria for direct recruitment. In order to be eligibility criteria for direct recruitment, part 3. In order to be eligible for direct recruitment to the post of assistant executive engineer, we are concerned with the assistant executive engineer in the service. A candidate must satisfy the following condition, namely, B, also see, minimum educational qualification. He must have possessed a degree in engineering or an equivalent qualification from any university or institution recognized by the government, or he must be associated member of the Institution of Engineering of India. Then age, you are over. Then, sir, kindly come to next page, page 6 of 2012 rule. Rule 7. This was originally there. Rule 7 is the selection by the commission. When, let's get it, page 6. When the government decides to fill up the vacancy in the post of assistant executive engineer by direct recruitment, government will communicate the number of vacancies in the post along with the reserve vacancies thereof proposed to be filled up. Then 2, the commission on receipt of the requisition shall in such manner as it thinks fit shall invite from eligible candidates. Eligible candidates means as required under rule 6. Then 3, this 3 was there, but it has been now deleted. The commission, after receiving all the applications, shall take steps to select candidate in the manner given below. A, selection shall be based on career evaluation and objective type, written test and viable test. B, weightage of career evaluation shall be 50% and objective type written test 40%. C, the career evaluation shall be made in the following manner. High school certificate 12.5, higher secondary, then degree engineering is 25%. Weightage on the viable test would be 10%. Then 4 is also deleted now. The commission shall prepare a list of selected candidates arranged in order of merit equal to the number of advertised vacancy on the basis of the marks secured in career evaluation, objective type, written test, and viable test. The commission shall prepare the commission shall prepare a common merit list taking account all categories along with separate merit list categories. This is rule 7. Now your Lordship kindly come to at page 11. In 2014, there is a little amendment. So far as sub-rule 3 is concerned, sub-rule 3 and 4 of rule 7 is concerned, that is at page 11. That was notified on 31st October 2014. Page 11. 2, 3. The commission, let's get it. In Odisha Engineering Service, method of recruitment, condition of service, rules 2012. For sub-rule 3, 4 of rule 7, the following sub-rules shall be substituted. Rule 3, the commission on receipt of the requisition shall take steps to select the candidate in the manner given below. A, selection shall be based on objective type written test and viable test. B, weightage on objective type written test shall be 90%. Then C, weightage on the viable test shall be 10%. Then 4, sub-rule 4, the commission shall prepare a list of selected candidates arranged in order of merit equal to the number of advertised vacancy on the basis of the mark secured in objective type written test and viable test. Then explanation, the commission shall prepare a common merit list taking into account all category along with separate merits categorized. Then sir, kindly come to page 12. This was amended again on 28/1/2021, which was the subject matter of challenge in the previous writ application. That is at page 12.
Before this, which is at page 11,
Minor.
there must be some rule original rule, which is called Odisha Engineering Service Rules 2012.
Yes, that is the rule I placed. That is that page 3.
Page 3.
Page 3. That is the rule. That page 3.
Oh,
That was published.
just a-
Sorry.
Oh, this is 2000.
Yes. This 2012 rule has undergone an amendment in 2014. Only in respect of 7, 3, and 4. So for the weightage and
No, but what was the purpose of your mentioning to this? This 2003 rules?
2003 rules, it is a rule where non-obstantive clause is there. It applies to all recruitment rules.
No.
That
That is confined to a particular service.
yes, sir. So that's what I'm coming to it.
2003.
Service means whether this assistant executive engineer or executive engineer, whether they come from state service or not, I'll bring to your attention.
That is 2003.
Yes.
2003 deal only with state civil service, no
Sir,
other service.
The service means state civil service.
State
Yes.
civil service.
Yes, but
So
you
not
also look
engineering
to
service.
just for a kindly. Rule 3 also says service oblique post. You also
Yes.
look to that oblique post.
Yes.
To any service oblique post. Rule 3. The commission, Orissa Staff Selection Commission, selection committee, or the appointing authority in case where such bodies do not exist or do not exercise their jurisdiction shall, for the purpose of initial appointment to any service oblique post, prepare a list through competitive
Any
examination.
service means this.
Service means
state
state civil service.
civil service.
Now, why I'm
No
saying so,
other
I've given that they have made a amendment, Orissa Civil Service 92. They have incorporated this executive engineer as a state service. I'll bring to us. The Lordship just, I'll take yours. I keep it in mind that your Lordship has posed this question. So
No,
far as rule,
there is difference. There is difference between, in fact, this rule,
Yes, sir.
the 2003 rules
yes,
lay down the criteria for selection,
selection.
for appointment, including promotion,
Right, sir. Right.
rules for state civil service, not for any other
So
service.
that is why I'm saying, can I take your Lordship to page? I've given that. Can your Lordship come to the page? Can your Lordship look to this?
That is different.
Yes, sir. They say
That is civil service classification.
no,
conduct.
what they have made in the Orissa Civil Service CCA Rule 1962, they have incorporated class 1 service and post. State civil service class 1, this service comes within that. Engineering service
State
comes.
service for the purpose of imposition of punishment, for the purpose of taking action, disciplinary action, and for the purpose of identifying the disciplinary authority. That rule must be there for that.
That CCA rules, your Lordship know that.
Yes. So
that is-
that is, in fact, sometimes the disputes arise as to who shall be the disciplinary authority.
That
And-
part is
and-
there.
And that classification is for that purpose only. This specifically deals with recruitment.
Recruitment. I am confined to recruitment. Your Lordship, just keep it in mind. This was my yes. No, I'll address on that question.
Mr. Ravtare, the one you are referring to is in which year? There's
This is 2003.
3. No. The other one where you're saying that it is included in that.
1962. 62.
So this says 2012 specifically relates to Orissa Engineering Service.
Yes.
This
But,
2012 one.
Yes, what they have done, because I don't want to confuse at this stage. They have made a schedule. In
can
that
do that.
schedule, they have incorporated this. That's your Lordship.
Yeah, now you can try to.
You can do that.
That's it. That's it. Sir. Then that's it. So that I can address my Lord Justice. That question was posed. I'd like to find out also if your Lordship. So now you also kindly come to that page 12. After 2014 in 2000, page 12. Page 12.
Yes.
This rule, this is by way of amendment of 2012 rule. You'll also kindly come to page 13. Page 13. we are concerned with Rule 7. And this amendment was brought into force on 28/1/2021. 3. For sub-rule in the page 13. Page 12 starts. Page 12 starts.
Yes.
This is a rule under Article 309.
Yes.
Page 12 starts. This is on 28/1/2021. Also come to the next page,
Yes.
page 13. In the top, in the said rule, in Rule 7, Roman 1, for sub-rule 3, the following sub-rules shall be substituted, namely 3. The committee at the receipt of the application shall take steps to select the candidates on the basis of the highest of the valid gate score of preceding 3 years of the date of advertisement, including the year of advertisement. Then 2. In sub-rule 4, the words and expression marks secured in career evaluation application of, I can remember that judgment. So, and before I take your lordships to the other provision, may I take your lordship just one thing, because your lordship had asked that question. 2012 rules, your lordship rightly said that about that 2003 rule may be applicable in respect of civil service only for that purpose only. But there is another provision, but that is relates to the promotion. That you also kindly come to page 7, 2012 rule. This part 4 is related to promotion, not recruitment. But if your lordship will look to Rule 10 at page 8, Rule 10, procedure for selection by the committee. The committee shall meet at least once in a year, preferably in the month of January, to prepare a list of officers as are held by them suitably for promotion to the next higher grade. If your lordship will look to A, B, C, the Rule 2003, that is under subclass C, the Odisha Civil Service criteria of selection for appointment, including promotion Rule 2003. That means they have taken aid of that 3 rule here in 2012. Of course, that is confined to promotion, I can say. But so far as your lordship is asking another question, whether it will be applicable to recruitment, because recruitment there is an overriding clause that notwithstanding anything contained in any other rule, recruitment rule, that rule overrides. That is subject to your lordship's acceptance. That's all. Then, sir, kindly come to this was the subject matter of challenge in the earlier writ application. I had placed that judgment. I will also again place a certain portion of that judgment. And if your lordship will look to the present amendment which was made, which is the subject matter of challenge, that is at page 15. Your lordship declared that 7.3 and 7.4 amended provision in 2021 to be ultra vires for 2 reasons. One reason is the consultation as required in clause 8, Article 23 has not been done, which is a mandatory in nature. And the second one, you also have said that level playing field, because they have not given opportunity, at least that the highest score in the 3 years, preceding 3 years, they have not given that opportunity. And you also kindly remember, so far the gate score is concerned, normally that the gate score is for 3 years, 1, 2, 3. That means the highest score that has to be taken into account that in the previous amendment.
Gate score is
Every year.
said of 3 years, you can take the highest.
Yes, that is but gate score has been defined also under the that 3 years. Validity is 3 years. One validity 3 years. Then sir, kindly come to the present impugned amendment that is at page 15, 26/9/2023.
No, validity for 3 years means even if you have taken it once, it will work for 3 years.
Yes.
But you will not get a chance of 3 chances of improving the score. So that is your disadvantage. So that is why it had been set aside.
That's right. That's right. And your lordship said, because that 21 by 2021 when made the amendment, you have not given any opportunity. And
Yes.
that's I think
An opportunity.
your lordship yes. That's it. So now your lordship kindly come to page 15. that new amendment they have brought in 2023. Your Lordship delivered the judgment in the other case on, because that is important, date certificate. Date certificate. On 1/5/23. Your Lordship delivered the judgment on 1/5/2023, that is Annexure 6 at page 63. I'll bring to Lordship's notice. And this amendment was again brought on 26/9/2023, or just 4 months after. 4 months after. And what they have made now, in the Orissa Engineering Service Method of Recruitment and Condition of Service Rule 2012, in Rule 7(1), for Sub-Rule 3, the following shall be substituted, namely, 3A, the Commission, after receipt of all the applications, shall take steps to select the candidates on the basis of the valid graduate aptitude test engineering GATE score and interview. Then B, the merit list shall be prepared on the, also this is very important, the merit list shall be prepared on the basis of the aggregate mark secured in valid graduate aptitude test in engineering GATE score carrying 90% weightage and interview carrying 10% weightage. That means 90% weightage has to be, was now diverted to GATE. That is and this was the subject matter challenge. Now you are find out, Chief Justice has asked me a question that there must be a regulation. So in terms of the Article 320
that there is a this limitation regulation.
Yes, that I have brought. I have enclosed at page 17. Page 17. Limitation, whether it is applicable or not applicable. The Orissa Public Service Commission Limitation of Functions Regulation 1989, in exercise the power conferred by the proviso to clause 3 of Article 320 of the Constitution. You also see 2C, government servant means a person who is a member of a state civil service or who holds a civil post. Then 3, it shall not be necessary to consult the Commission on any of the matters specified in subclause A, B, and C of clause 3 of Article 320 of the Constitution. A, B, C. A relates to the post and service to which appointment is made by the authority other than the state government. B, the chairman and members of the commission. C, the advocate general. These are excluded. Then you also see government advocate, assistant government advocate, public prosecutor, secretary staff, so and so, post of private secretary, so and so. Then I is important. Civil services and civil posts other than those in Group B, carrying scale of 6,500 to 10,500 and above, and Group A. We are concerned with Group A. Now, Group A, provided that commission shall be consulted in all cases before final orders to withhold or withdraw a pension. We are not concerned that. That's the next page, page 18, Rule 4. In regard to the services, Rule 4 at page 18. In regard to services has been defined, and post to which appointment are made directly by the state government, it shall not be necessary to consult the commission on any of the following matters. Creation of the organization post. Then C, the general method of recruitment, that means the services and posts to which appointment are made directly by the state government. That has also been somehow referred to in clause 3. The general method of recruitment to a service or post, that is whether recruitment should be made by 1, examination, or 2, selection, 3, promotion, 4, transfer, or by combination of 2 or more these methods. In the latter case, the proportion in which recruitment to a particular service should be made by each method of relative service in service of candidates recruited by different methods. So this is the exclusions made in terms of the provision under Article 20, subclause 3. And if you Lordship will look to the earlier provision of Regulation 52 that has been repealed at page 19, that is clause 12, last but one paragraph. The Orissa Public Service Commission Limitation and Functions Regulation 1952 is hereby repealed. So this is the exclusion clause. Then your Lordship, because this has undergone a little amendment. If your Lordship 20. This 89 amendment has been, the 89 regulation has been amended to certain extent that clause I, civil service, that if your Lordship will come to page 20. This was on 20th October 2014 in exercise the power under subclause 3 of Article 320 of the Constitution of India. The Orissa Public Service Commission Limitation Function Regulation 89 is amended. What was the amendment? It also come to 2. In the Orissa Public Service Commission Limitation of Functions Regulation 89, in sub-regulation 1 of Regulation 3, for the following clause shall be substituted, namely, civil service and civil post other than those in Group B carrying scale of pay 9,300 to 34,800 in the pay band 2 with grade pay of 4,600. The earlier that was
because of the scale.
Scale has been changed. Yes, revised scale. Yes, that's correct. Then, sir, this page 20, your lordship, kindly, this has been taken into account by your lordships in the division bench. I'll take your lordships after placing this. 21 is the consultation before incorporating that provision of 7.3 in the year 2021 to the Orissa Public Service Commission, which was produced before this honorable court in the earlier writ application. We have also brought it by you under the Right to Information Act. Let's come to page 21. This is the consultation of the OPSC's opinion is this. This is the opinion of the OPSC. Sir, this is on 19/2/2020. Sir, subject, amendment to Orissa Engineering Service Method of Recruitment and Condition of Service Rule 2012. Reference so also. In inviting a reference to the letter on the subject cited above, the draft notification within bracket amendment rules forwarded by your letter dated 4/10/2019 is hereby concurred except para 4 to be read as under. That's why skip over. That amendment already I have placed. I need not take. So yes. You'll also look to preliminary examination. The OPSC has said that how the examination is being conducted right from 2012 onwards. Preliminary examination, main written examination, viable test that has been described from subclass B to subclass E. And ultimate opinion of the commission is this in the last paragraph. The commission had letter number so-and-so dated 4/3/2016 had recommended a two-stage written examination along with the viable test to ensure meritocracy of the candidates in the dual field of theory and practical knowledge. There was no recommendation to conduct. There was no recommendation to conduct the examination on the basis of gate. Notwithstanding above, the proposal was extensively deliberated by the commission and the representative of the department on 31/1/2020. The commission is of the opinion. Let's mark it. The commission is of the opinion that the syllabus has not been changed till now. The syllabus of GATE designed for entry to higher education institution is not suitable for selection of officers to the Group A category. We belong to Group A category of the government with the laid down terms and conditions under the Article 311 of the Constitution of India. Then next page, paragraph, page 23. However, if the Department of Water Resource consider to ignore the recommendation of the commission, which are mandatory in...
Mr. Rautray, I don't have page 22.
Oh my God.
Oh my 23 of this, no, which you have given.
22, Mila.
22 is not there.
22 of what?
Not my
Today's.
compilation. Sorry, Mila. Extremely sorry, Mila. Justice, madam. Sorry, I'm extremely sorry. I'm extremely sorry. That's it. That's it. Thank you. Next. Now, sorry.
Letter of the.
No, it is not that it has been not given to us and given to you. It has not been given to anybody.
No, he has given a letter of the OPSC that page 22, but he's
Exactly.
reading another letter.
Still, they have done it in the morning.
It
So
happens.
I'm not in a position to be like, also kindly.
And also my learned senior also go through that amended rule that he has given, that 2003 rule. In the meantime, that has been amended. He should go through that rule also.
No.
To
You
get the
see,
opportunity,
we
it's all right
should
for-
we should confine ourselves to
Required.
these rules because you are challenging this.
Right.
So whether the rules violate any provisions of the constitution or not, that is only the question.
Right. That's great. Yes.
Yes.
You're saying kindly have a glance
Yes.
to that. The opinion, the operative portion of that opinion.
Yeah.
Last question. You would also. My.
Read it loud. Read it loudly, no problem.
Yes, sir. The, I've given to my Lord Justice.
Yes.
Yes, yes.
I think your lordship dealt with in the other case, I'll show that. Then the last portion is this. However,
Yes.
because the syllabus, your lordship kindly mark it, that so far syllabus is concerned, there is no change in the syllabus. Till today. Yes.
Yes.
However, page 23, I think that is, however, if the Department of Water Resources consider to ignore the recommendation of the Commission, which are mandatory in nature as regards to amendment to the recruitment rules, the Supreme Court has opined and directed that such decision of the executive are subject to judicial review. In addition, the proposed draft notification also need to surpass the amendments by notification dated so and so, and also examine the notification dated so and so prior to issue of suitable instructions. Then, Judge, may I take your lordships so far as this particular the opinion of the OPSC was also placed before the earlier division bench. Your lordship may kindly have a glance to page 149 of the brief.
Yes.
149. Capital B. While amending, you have to get it, page
This is
149.
Tarani sir or Satyavrata sir.
Satyavrata sir.
Okay.
I'm referring to Satyavrata. I'm WPC.
Yes, that.
I think.
Again,
That internal page 88 of that judgment, but running page 149.
Yes.
While amending the OES rules 2012, the provision of Article 323 of the Constitution and the rules of business have been given a go by.
You are reading 149.
9 of Satyavrata's house case.
83 83.
Internal page 88.
Internal page 88.
Yeah, yes.
Internal page 88. It's 154.
In the other brief, Lord, yes.
Annexure
I'm
7 is
referring-
part of Annexure 7.
Yes. I am referring to 8166 of 2024, Satyavrata sir, where I am agree. I am happy.
Satyavrata or Tarani? Which one?
Satyavrata sir.
This is
Oh,
So there are three matters. I am appearing in one.
sorry.
Sorry.
Satyavrata I could not find. 149.
Yes.
Yes. While
149.
149, running page 149.
Internal?
Internal page 88. Internal page 88 the judgment. 88.
Yes.
I think. While amending the OES rule 2012, the provision of Article 323 of the Constitution and the rules of business have been given a go by. It has not been brought to our notice that government has framed any rule under proviso to Article 323E of the Constitution that it would not be necessary to consult the OPSC in the matter of recruitment of members of the Orissa Engineering Service. On the other hand, it is admitted case that OPSC has been consulted and did not agree to the part of the proposed amendment relating to Rule 7, that is the method of selection of the assistant executive engineer on the basis of the gate score. But this consultation with the OPSC has been made an empty formality, and such shift has been made of its advice. Although the OPSC has consistently expressed its reservation to amendment of Section 7 of the OES Rule 2012 by substituting Rule 7.2 and 7.3, that is the method of selection, by replacing the marks awarded for career written examination via bus with the gate score. And this had been brought to the notice of the Law Department and GA Department and PG Department and the Chief Minister, but it had not been brought to notice of the Cabinet. That is another part.
No, that is the main part.
But that is the main part. So far, that judgment, the 323 is
No,
concerned.
no, there it had not been brought to the notice of the cabinet. There
Yeah.
they placed the thing that it has recommended. It
That's
was
it.
not correct.
That's it. But I'm trying to say that so far the consultation of the OPSC is concerned, that they have said that the syllabus, this is the syllabus has not been changed, and this is the consistent opinion of the OPSC that amendment should not have been done.
But what is the scheme of gate? Whether the gate is held for different branches of engineering, or there is only one?
Different branches. I
Like
was told that different
For,
branches.
for,
I'm
for
not-
mechanical, there is one. Is there any? Just
Yes, yes.
trying to understand.
Yes, that's it.
All
That's
right,
it.
we're just coming back.
Sir. Sir, now at your aspect, kindly
Just
come.
a minute, sir.
Oh, sorry.
So any take on gate? Gate, whether it is.
Maybe compilation will include some documents regarding grade, brochure and all that. That's idea to your lordships.
Whether it's common for all the engineering graduates? or it
Engineering, that
depends
is
on
one
their-
gate exam,
Huh?
common for all.
It's common.
It's a common for all.
There's also a gate for MBBS. Architecture also. Architecture also. This is confined to all engineering,
All branches.
all branches.
Under this rule, my lord, the
Thanks,
so far electrical branch is concerned, the result of the recruitment has all published. Now, development is day before yesterday.
What?
For the electrical branch, my lord, they have an examination basing on the, and the result has also been published.
So this is for this.
This is for that civil
Civil and mechanical.
Civil and
Civil
mechanical.
and mechanical.
Electrical result published, basing on the rule.
No, basing on GAT or basing on?
Gate.
GAT
Rule
only
is
that.
all. Rule is same, they are holding recruitment. This
Right,
is for
right,
civil and mechanical.
Right, so
This for
that-
particular advertisement. Other one for the electrical.
So electrical, they have not, nobody has
Nobody
challenged.
challenged that. Result published.
Acha, acha.
Can your lordship, so far the gate is concerned, the page 235, they have issued a correction now. This advertisement, which is now subject matter of page 235, annexure 14.
Yes.
Lordship, see the clause 5. Instead of clause 5, this is a correction to the first correction was issued, second correction, the third correction. The instead of clause Roman 5 of para 9 may be read as follows: certificate showing valid gate score on the subject gate paper, inverted comma, of civil engineering, public mechanical engineering, whichever is applicable, That means I hope this is different subject. So for the civil,
This is what. Like this indicates that there is separate gate for civil.
Civil and
Separate gate for mechanical.
not common. In fact, it's not common. And it is a
Subject wise examination. ma'am.
No, online there's a GAT test papers and syllabus is available.
That is there with us. If my lord want, you can produce it.
that is the
My lord,
Just what we are trying to understand.
Yes, sir.
From-
Yes,
From practical aspect and then from
yes, sir. Yes.
the legal aspect also.
Each subject there is examination.
And it says the examination is organized by the Indian Institute of Science, Bangalore, and the IITs.
The group of
So they do.
IITs.
And under that Ministry of Higher
Yes.
Yes. Then you also kindly comment page 159, the judgment, internal page 98, running page 159. so far the consultation of the OPSC is concerned. At paragraph 30,
You are reading?
the judgment that is at, I was reading at page 149. 149. On the other hand, I was just capital B, that paragraph. I'm reading it again. While amending OES Rule 2012, the provision of Article 23 of the Constitution and the rules of business have been given a go by. It has not been brought to our notice that government has framed any rule under proviso to Article 323E of the Constitution that it would not be necessary to consult the OPSC in the matter of recruitment of members of the Orissa Engineering Service. On the other hand, it is admitted case that OPSC had been consulted and did not agree to the part of the proposed amendment relating to Rule 7, that is the method of selection of the assistant executive engineer on the basis of GATE scores. But this consultation with the OPSC has been made an empty formality, and short shrift has been made of its advice. Although the OPSC has consistently expressed its reservation to amendment to Rule 7 of OES Rule 2012 by substituting Rule 7.2 and 7.3, the method of selection by replacing the marks. This was I was placing. Then also kindly come to page 159. That is the conclusion, I think. That is the conclusion. Page 159, para 38. Rule 7 of the OES rule on amended part still provides that selection made by the Public Service Commission. But no role has been assigned to the Public Service Commission by the amendment that has been implanted by deleting the original sub-rule 3 and sub-rule 4 of Rule 7 of the OES rules, Orissa Engineering Service rules. It is the complete exclusion of consultation with the Orissa Public Service Commission. This is a unique example applying power of sovereign places against this one. This is so far as the consultation is concerned. But so far the judgment of that division bench of the Patna High Court, Your Lordship have gone through that judgment. Only one portion I'll just reiterate, that is because Your Lordship will look into the judgment again, that if Your Lordship will look to page 162, we'll start from page 161, one paragraph only, para 42. Para 42, that judgment has been referred to, and it has been said like this, finding of the Honorable Court is like this. In so-and-so case, the Patna High Court was examining virus of the amendment of Bihar Polytechnic Education Service Rules 2014, by which the requirement of written test and evaluation of the teaching skill was deleted, and it was provided by evaluation of percentile secured by the candidate in the graduate aptitude test. Yet, in engineering examination, selection will be made. The said amendment was challenged in a few writ applications. While deciding the controversy, the Patna High Court has observed that though there is no apparent breach of Article 14 of the Constitution, but for introduction of GATE selection method, the candidate having higher qualification or experience will not get due weightage during the viable test. It has been observed thereafter that there can be a preferential category within a particular category, but a scheme which deprives the candidate from consideration against a particular attribute in its entirety suffers from vice of arbitrariness, besides being discriminatory and lacking reasonableness. In fact, the change that has been brought about has created a class within a class of candidate. In so far as the evaluation of the work knowledge is concerned, the object is entirely missing. The quotation from Patna High Court judgment, even if the state on that you also have read it, and next page you also kindly come to page 163. What is the finding? So far as page 163. We are also confronted with the similar circumstances. Finally, the Patna High Court held the said amendment and hence the same is set aside entirety. That is, of course, the finding so far as the Patna High Court judgment is concerned. And one thing I'll show Your Lordship, I had shown Your Lordship from the paragraph that Your Lordship remembered that, but again I'm showing to Your Lordship that is paragraph
159.
Para 20, para 27 at page 150. I'll show that what they have done at the present. Page 153. That is an additional ground for which your lordship have interfered in the amendment matters. 153. Running page 153 in the brief of Satyabrata Saab. WPC 8166 of 2022.
You are referring to the part of the judgment.
Part of the judgment.
Para 27.
Part of the judgment. In internal page 92 of the judgment.
Yes.
Let's get it. An additional ground. I'm trying to just compare in the present case, present scenario, how they have done. An additional ground of quashing the impugned advertisement is that the candidate have not been provided enough time, public opportunity to appear in the gate examination thrice before publication of the advertisement dated 18/3/2023. The highest valid gate score for the preceding 3 years from the date of advertisement has been provided in the method of selection in the advertisement, thereby depriving candidates who had not appeared for the gate examination in the year 2021. The process for which admittedly began in 2020 before the application of Amendment Rule 2021, which were published on 28/1/2021, while the advertisement has been published on 18/3/2023 of a level playing field, placing them at a disadvantageous position as compared to candidates who were able to appear in the gate examination thrice before publication of the impugned advertisement and thereby discriminate against them. And accordingly, Lordship declared that 4.1 and 4.3 to be ultra vires. Now, Lordship, look to my date chart. So far as this year is concerned, Lordship, I have given a date chart last time, but just kindly come to page 2 of that date chart.
Yes.
Yes.
Another one or the same one you had given?
Same
Yes.
last.
Yes, yes.
You also come to serial number 5. Your Lordship delivered the judgment on 1/5/2023. I think that 7.3 and 7.4 ultra vires. Let's get it. 1/5/2023, WPC number 1573/22 batch. We have filed challenging constitutionality and so on. And the Honorable High Court by judgment dated 1/5/2023 was pleased to declare and strike down Rule 21 amendment rules. Then also see 1/5/2023 judgment was delivered. On 30/8/2023, online application started for applying for GATE 2024 after the judgment was delivered. And the last date was fixed to 29/9/2023 for making application for GATE. And on 30/9/2023, the amendment came into force. This amendment, subject matter of challenge, that was on 30/9/2023, incorporating same thing, GATE.
No, but does it contain 3 years?
3 years.
3 years, where is it?
The present one, they said
Only GAT score.
highest valid gate score.
Yes.
Valid gate score means 3 years, amongst 3 years.
How can it be?
Gate score is valid for 3 years.
One gate score is valid for 3 years.
Yes, valid for
For
3
3
years, but
For-
they did
now-
not say that last 3
No,
years.
they said that
Valid gate score.
Valid gate score. That should not be any
So that is the
confusion.
difference.
Yes.
Yes, yes.
The amendment came into force on 39/2003. On 28/12/2023, the advertisement was made. 28/12/2023. And the process of online application was started pursuant to the advertisement on 12/1/2024. But they issued a corrigendum on 12/1/2024. Second corrigendum on 19/1/2024. Third corrigendum on 19/1/2024. And after the last date of making application was over, on February 2024, GATE examination was held. That means after last date of submitting application was over, the examination of the GATE was only held in the year 2022. So now the only question for consideration, that paragraph 26, which I just now placed before your lordship, that paragraph 26 said.
One moment.
Yes.
When was the advertisement published?
The advertisement was published, that is there at serial number December 28/12/2023, serial number 9, 28/12/2023.
So this rescheduling the date of making online application,
The last submission of online application was 19/2/2024. 19/2, that is at serial number 15. And gate examination was held in the month of February 2024. Result was published subsequently.
No. So they have fixed it after appearance in the GAT examination. But for the GAT examination, I think applications have to be made sometime in September or October, if I'm not mistaken.
Yes, that.
What is that?
You also look to this. That is, last date of making application for application is 29/9/2023 at serial number 7. 29/9/2023 was the last date of making application for appearing the GATE examination 2024. And the amendment was incorporated on the next day, that is at 39. Now, one thing I'll show you ourselves. This is advertisement. So far as the next question. Let's say look to page 191. As the state other departments are concerned, let's say look to this. Let's say kindly come to page 201. 201. This is in Panchayat Raj department, same assistant executive engineer. Here in the water resource department, they have adopted this method of GATE, but referring to the, also look to page 201, advertisement number 33 of 2023-24, recruitment to the post of assistant executive engineer civil in Group A of Orissa Panchayat Raj Engineering Service cadre under the Panchayat Raj department. If you also will see the method of recruitment, that is at page 202. The competitive examination, at serial number 5 at page 202. The competitive examination for recruitment to the post of assistant executive engineer civil shall comprise the following successive stages. A, preliminary examination that will be conducted by OPSC, objective type MCQ pattern. B, main examination, objective type MCQ pattern. C, Viva's test. The preliminary examination shall be one paper of 100 questions carrying 100 marks with duration of 1.5 hours with objective type question of multiple choice with negative marking of 25% of every wrong question allotted to that particular question. Then next page 2.
Sir, they are not relying on GAT.
They are not
so that is
relying on
your
GAT.
case.
So far as in 2023-24, that's it. Now I have consolidated my note of my submission. I close my argument.
Do you mean to say no department of the government is relying on GAT? Because just Mr. Das informed that electrical engineers, they have relied and that is complete.
You also see the varying from each department, this department to the other department.
Yes.
They are controlled by G department. And also, I have prepared a short bullet points for your lordship. This is my entire submissions. Or copy it. So I have already placed before lordships. I have just consolidated it. And this is a part of the records. My short note, 2-3 pages. The Orissa Civil Service criteria, Mr. Khuntia was showing me. In fact, I found also in 2014, there is an amendment, but that amendment, so far the examination and so far the overriding clause is there, that still continues. I'll show that, that's the other part. So, Orissa Civil Service criteria for selection for appointment, including promotion rule 2003, has been framed under Article 309 for regulating criteria for selection, initial appointment, promotion, the state service and post. Rule 3 of the state rule provides for preparation of selectees through competitive examination. Further, Rule 5 provides that the provision of 2003 rules shall have overriding effect, notwithstanding anything to the contrary contained in any other recruitment. Accordingly, since 2003 rule provides for selection on the basis of competitive examination, whereas 2012 rule, the role of the OPSC to conduct examination has been completely ignored. So therefore, Rule 3 read with Rule 5 of 2003 rule will override the provision contained in 2012 rules. Then 2. The Commission in its letter dated 19/2/2020 addressed to OP number 1 during consultation for introduction of GATE for as a method of selection by way of amendment in 2012 rule has found that the syllabus of GATE is designed for entry into higher education institution is not suitable for selection of officer Group A category of the government, which with the laid down terms and conditions under Article 311 of the Constitution of India. The same has also been discussed in paragraph 25 of the judgment dated 1/5/2023.
Mr. Rautre, sorry for interrupting. This time, they've consulted the OPSC again.
They say that they have consulted, but they have not produced any document, how they have consulted and why OPSC has altered its stand immediately within a short time. That is also.
Okay.
Then the 2012 rule was amended in the year 2021. 3 stages selection, that is preliminary examination, written test and viable test were substituted with GATE score. But fact remains OPSC did not concur to introducing GATE. That is at para 25B and so on. Then para 4. This honorable court in its judgment dated 1/5/2023 held that the case of Bihar, Patna is similar and found the amendment to be discriminatory as it creates a class within a class. Then 5. No uniformity in the recruitment rule for recruitment to the post of assistant executive engineer, as different method is adopted for recruitment to the post of assistant executive engineer by the government in different departments. Hence, such amendment is illegal and in violation of Article 14 and 16 of the Constitution. The last recruitment to the post of assistant executive engineer was held in the year 2019. Thereafter, the exam was held in 2023. GATE score is valid for 3 years. Candidate cannot be expected to appear for GATE examination every year so as to obtain a GATE score in order to participate in the recruitment process. Exercising the power conferred under the proviso to clause 3 of Article 320, the Odisha Public Service Commission Limitation of Function Regulation 89 was framed. As per Regulation 3, it shall not be necessary to consult the Commission in any of the matters specified in subclause A, B, and C of clause 3 of Article 320 of the Constitution. As per subclause 1 of Regulation 3 of clause 1, the civil post other than Group B and above and Group A, the consultation with the Commission is not necessary. In the instance case, the post in question, that is Assistant Executive Engineer, being a Group A post, consultation with the Commission is necessary, and such civil posts have not been exempted in such regulation. 8. Amendment incorporating GATE deprives candidate for consideration for evaluation on their work knowledge and teaching skill because they have not passed GATE examination is arbitrary and discriminatory, as well as the lack of objects sought to be achieved. Then 9. Conflict between Rule 6 and Rule 7. Person eligible as per Rule 6 deprived to participate in the recruitment process in view of Rule 7 of the impugned amendment. The para 10. The impugned amendment is in clear violation of Article 321 of the Constitution of India, where the function of the OPSC has been reduced to a ministerial job. That is the finding in the earlier judgment. Then para 12. Candidates having brilliant academic career will be left out from the zone of consideration. Then 13. A person already having postgraduate degree cannot be expected to appear for the GATE examination. Then 14. Purpose of GATE and is for prosecuting higher studies. Public sector undertaking resort to recruitment based on GATE score due to paucity of time to conduct examinations. These are my examples. My Mr.
Yeah.
Khalid, I give some note judgments.
May it please, Manoj.
Do you want to add something?
Manoj, I'll add a little bit, but more or less, Manoj has covered the field. So I'll, Manoj, most humbly, Manoj, I'd like to add a few Manoj, aspects or facets, as I may put it before your lordship, Manoj, to these arguments, which in essence have been advanced by my learned seniors, Manoj. One is, Manoj, my first submission for your lordship would be that Article 320 is clause 1 of the Constitution, Manoj, has been read and reread before your lordship, Manoj, time and over again. I'll just like to, Manoj, take your lordship's time, valuable time, Manoj, place it again. Just 3 lines in that article, Manoj. So as to, Manoj, put my argument before your lordship's in perspective. 320 clause 1 of the Constitution. To, Manoj, put my argument in perspective before your lordship, Manoj, is this. Functions of the Public Service Commission. Clause 1. It shall be the duty of the Union and the State Public Service Commissions to conduct examinations for appointment to the services of the Union and the states, Union and the services of heavily. Now, my lords, what emerges from this is, my lords, two things. One is that the Commission has a bounden and solemn duty under the Constitution. It's a mandatory duty and an obligation. Two, my lords, is a mandatory constitutional obligation to conduct an exam.
If the commission is asked to do it.
My lords, if the Commission is asked to do it, correctly, man, correct, my lords. If that rider is always there. And secondly, my lords, for appointments to the services of the union and the services of the state respectively, my lords. Services can also include, my lords, a wider net, that is civil services, as your lordship was pointing out, and also, my lords, other services like engineering services and all, which are covered, my lords, under these rules. Now, my lords, I'll take your lordship.
No, services would mean all the services.
All the services under the excluding those which have been kept.
Limitation of functions, regulations.
Which have been kept. I would go to court. I've given a couple, two compilations. Your lordship state with me. Report like it. In this context, my lords, the first report which was placed of the UPSC, that your lordship finds at page 68. Of the, my lords, compilation which I have given. Page 69, the report, this was the report, my lords, which was placed before the legislature as to what are the duties as understood, my lords, by the UPSC itself, the commission itself. And this is the first report after immediately the constitution came into force, my lords. Your lordship comes to page 70. Functions of the commission. The commission have been prescribed in Article 320 of the Constitution. They are more or less the same as were prescribed for the Public Service Commission India and the Federal Public Service Commissions. Briefly, they are recruitment for all civil services and civil posts. So this would, my lords, answer the query that whether it's limited only to civil services, it will mean, my lords, all services. Recruitment, one, written exams with or without a viva voce exam or interview to supplement them. So, my lords, conducting a written exam by the UPSC is, my lords, mandatory.
No.
My lords, in my most humble and most respectful submission, my lords, that as my lords would emerge.
Now, there are various posts.
My lords.
For which the recommendations are required to be met by the UPSC.
My lords.
Without written examination.
My lords,
yes. So therefore, when it says one written examination with or without viva voce, and second, and third, promotion. There are three modes of selection.
My lord, three
by
modes
the
of
UPSC before a recommendation is.
In all these, my lord, I would put it little differently. In all these spheres, my lords, UPSC is to, my lords, have its role.
Yes.
Where it is not exempted under subclause 3. If exempted under subclause 3, my lords, UPSC would have no role.
Yes.
But if not exempted under subclause 3, my lords, UPSC would have a role.
Yes.
So if it comes to the recruitment, my lord, my most humble and most respectful submission before your lordship would be this, that a written exam initially was what was my lords.
Please, it's clear. When you are reading this, even otherwise,
my lords,
there is no this thing. When you read it is the duty of the function and duty, then it is required that the BPS, the OPSC or UPSC or BPSC has to.
Why I would
they have a to conduct. It will depend on the recruitment rules, the process.
I entirely agree
and
with
therefore
you.
You come again to this which you are referring to. This will make it more clear.
my lords, while there's no, my lords, I'm not questioning your lordship's interpretation in this, my lords. I agree, my lords, I cannot question that interpretation, but in the perspective of Article 14, my lords, from the,
No, when you say,
my lords,
just read what you were reading.
my lords, page 670, my lords.
Functions of the commission have been prescribed.
My lords, have been prescribed in Article 320 of the Constitution. They are more or less the same as were prescribed for the Public Service Commission and the Federal Public Service Commission. Briefly, they are recruitment for all civil services and civil posts by one, written exams with or without viva voce exams,
Two,
or interview to supplement them. Two, interview,
only
only interview. Three, my lords, promotion,
promotion.
my lords.
And then come to B.
My lords, advising government on disciplinary matters affecting government service.
This is also one of the.
My lords.
C.
C, miscellaneous such as advising government in respect of government servants, claims for cost. My lords, we are also not.
So this is.
This is the entire range of my lords
It
functions.
is not
No.
that before making any recommendation, the commission is required to hold a written examination.
My lords, I concede to that, my lords. But my lords, the point is in perspective, when we are taking candidates from across the spectrum, my lords, Article 14 gives even candidates who have not appeared gate, my lord, because gate, as your lordship, my lords, I'll produce those documents, my lords, before your lordship. Gate is not a mandatory exam, my lords, save and excepting.
No, C.
My lords,
Here state is an employer.
my lords,
Employer is of the view
my lords,
that the gate examination has maintained a sanctity.
my lords,
And if someone qualifies in the gate examination,
my lords,
in the opinion of that employer,
my lords,
he having candidates, he or she.
my lords,
So, and the gate examination, the value of the gate examination is such
my lords,
that it can be given 90% of it is. So this is the decision of the employer.
my lords,
That power the state has. All
My-
right.
my lords,
Now, before taking that decision, it is the duty of that employer to consult a body,
my lords,
which is commission.
my lords,
Advice of the commission is not binding. All
my
right.
lords,
So it consulted a commission, consulted the commission,
my lords.
and now based on gate, the employer has decided. How do you question? On what basis?
My lords, I'll come
And
to that.
Mr. Pallit, if I've understood currently, in the first time when there was a challenge, the commission was against it. But this time, I think commission has recommended.
The commission, when its role was totally, my lords, negated, when the commission was totally negated, commission said, we don't agree.
Not
Then they
negated.
said, all right.
Not negated. They took its opinion,
They took its opinion, they said, we don't agree.
but suppressed it.
Suppressed.
put it before
and
the cabinet.
Wrongly informed the cabinet.
Because in
that-
fact, if you go through this
that
document,
your
you are
lordship has
referring to.
observed in your lordship.
No, you're referring to this document. There also it says that even they have the right to ignore but they do
They
it in
can.
rare instances,
But
but
they
they
should
have to
give
follow a
reason.
procedure. Yes.
And such reason should be placed before the legislature. It should
So,
be
yes, but that is not necessary now because
now
commission
since
has-
they have already given the mallards. So mallards, there are the rules, initial.
No, so if I'm not mistaken, basically now we are challenging the role, what PSC has done. Because government has followed the procedure, but PSC has said it is not necessary. You
we
conduct
are
it.
challenging the entire amendment that your lordship should, mallards, Article 14.
All right, okay, all right.
Article,
okay,
mallards, I'm
right, right.
developing my argument, mallards, in Article 14, that our education system is, mallards, it's like a pyramid. Article 14, mallards, ensures.
But another thing, you were referring about experience and everything. Here, there is no question of experience. Are they giving you marks for experience?
No, they have not.
That was the case in the Bihar case. Because they were making appointments for lecturers, I understand. So that is why experience was important.
Weightage, no, Bihar case also said one more thing. Bihar case said one paragraph.
But Bihar case was basically employing
Bihar case
the
also said
polytechnics.
that amounted to discrimination against MTechs who are, my lords,
Higher qualified, so they can be
higher
better
qualified
teachers.
who had no necessity to take a GATE exam. So this was a discrimination or discriminated against those kind of candidates who had no necessity, who had no use, who did not require to take a GATE exam. Similarly, my lords, the original rules 2012.
We are prima facie of the view that your attack
My lords,
can be successful
my lords.
if you are in a position to demonstrate that the candidates did not have the opportunity to take GATE examination and have the score for the purpose of participation in the process of selection. That will lead to altogether exclusion of those who did not have the opportunity. One.
My lords.
Two, you can, though that's very difficult for the court to hold, but still the court may hold that the GATE examination
It's not proper.
is not at all adequate for the nature of service.
This is a recruitment
which
exam. That would have been my next
recruitment is
submission.
being
Right.
So this is second.
Man.
And third, more difficult. Again, that see, you are basing your decision, you are not basing, you are required to have consultation with the OPSC. OPSC had formed an opinion and given you some advice. You are not bound by the advice. But this time, the OPSC changes the advice. All right. And based on that, so when you take the second point as suggested, we cannot suggest, but as we were expressing, when you take the second point that this is not the proper qualification for the nature of service, then you can possibly take that the UPSC had already given in detail. And thirdly, as has been pointed out, Mr. Rautray, that the syllabus is syllabus for examination is still there in the rules that could have been
That
done
could have
away
been
with.
normal.
And lastly, in fact, I was under the impression, and I'll again examine that you were referring to a state civil service.
Yes.
So I was prima facie under the impression that state civil service means state civil service like
Administrative service.
administrative service or administrative services. It seems that because there are only 4 or 5 rules, so it does not refer to the cadre. Had that civil service rules referred to cadre, the matter would have been different. But it does not refer to any cadre. This will be a state civil service and this number of posts, because see, there is difference between when they define civil service, state civil service, and service means state civil service.
My lords.
Now, in the rules, service means state engineering service. All right.
My lords.
But whether the engineering service is part of the civil service of 2003, yes, that should be addressed. I have not brushed aside
Yes.
altogether that
That I have
argument.
kept in mind to verify that also. Again, because your Lordship have pointed out that, I must verify that.
Now, my lords, I'll also draw your lordship's attention to, my lords, basically two articles also along with 320 clause 1 have to be read, my lords, in my most humble and most respectful question, my lords, have to be read in perspective of Article 16 and Article 14, my lords. One is, my lords, Article 14, state shall not deny to any person equality before the law or equal protection of laws within the territory of India. India, my lord, there are various shades to Article 14, my lords, discriminatory, how it can be discriminatory. One shade has been addressed in the Bihar case, my lord, that people who are candidates who are not required to take my lords, GATE exam, who are more qualified, higher qualified, my lords, who need not take the GATE, they are being discriminated. And also, my lords, in the perspective of the 2012 rules, which my lords say that in order to be eligible, my lords, the eligibility rules, my lords, this rule 6 of the present rules, that the eligibility criteria is a simple, my lords, BTech degree. So if I have a simple BTech degree, the rules guarantee me and a foot in the door. Maybe I will not sit on the podium tomorrow. I will not be selected because you may have higher criterion for selection. You may make the examination very stiff. You may make the exam very tough for me to clear. I would, of a particular syllabus geared towards meeting the requirement of
You
GATE.
get a chance to compete.
I will get a chance to come. That is what is protected by the.
You have a very difficult, when you are making that submission, it's
Well,
very difficult. Because it is the employer's choice,
Mallards.
which examination shall base for the purpose of.
Correct.
That is like, you can draw a parallel. Suppose, adding to your submission,
Mallards.
that if for appointment to the post of medical officers,
Mallards.
the government decides that those that their selection will be based on their NEET PG examination.
Mallards.
All right. So NEET PG examination for appointment as medical officers,
Mallards.
which they are not required to take for the purpose of PG admission. And if they know that they qualify, why should they take PG examination? But if they are willing to take state service, for that also they have to appear for that examination. These are
Mallards.
One thing, you have to be given enough opportunity to appear in at least one
That is
examination. They took away the 3 tries, but from the dates I find there is some problem about 1 try also.
One try. Now they have modified it to
Show
one
that.
try because
So-
they had to fit in for that.
Show that.
Mallards, also the equality of opportunity and matters of public employment. That is exactly what I was trying to.
equality of opportunity. In fact, here
Mallards.
will not apply for the reason
Mallards.
that everyone is being treated equally.
Within that, within the all GATE qualified candidates are being treated equally. Mallards.
One qualification, so that applies for all of them.
Mallards.
Quality.
Mallards. That is. There's another issue, Mallards, I would like to point out to your lordship is this, Mallards, that this GATE exam is not conducted by, is not recognized by the rules itself. So in order to, Mallards, employ GATE, there has to be some definition or some, Mallards, definition in the definition in the rules.
That what is GATE?
Yes, what is GATE? Why GATE? There can be a better exam than GATE, my lord.
No,
Again, it is up to that.
It is that I will not venture there, my
Who
lord.
conducts GATE?
My lord.
Who conducts GATE?
GATE is conducted by my lords.
Indian Institute of Science.
Institute of Science,
Along
page
with the
26 of
IITs. Along with
my
the
lords,
IITs.
compilation. Graduate aptitude test in engineering is a national level exam conducted jointly by the Indian Institute of Science, Bengaluru, and 7 other institutes of technology, IIT Delhi, IIT Bombay, IIT Guwahati, IIT Kanpur, and on behalf of the National Coordination Board, Department of Higher Education, Government of India. GATE is a my lords, computer-generated based test and evaluates the comprehensive understanding of the candidates in various my lords, undergraduate subjects of engineering, technology, and architecture, and both undergraduate and postgraduate subjects in humanities and science. In GATE 2024 will feature 30 papers distributed over 4 days. The GATE score reflects the relative performance level of candidates in a test paper. GATE 2024 score will be valid for 3 years from the date of announcement of the results. Qualifying in GATE is useful for seeking admission and or financial assistance to master's program and direct doctoral programs in engineering, technology, architecture, and doctoral programs in relevant branches, engineering and technology, my lords, in institutes supported by MOEF. So therefore, my lords, it is some kind of a exam which is designed to test whether you are good, and also for financial aid, whether you are good enough to, my lords, get admitted to pursue higher degrees in, my lords, education or also financial aid given by the government. But what we are,
The question is
my lords,
that that examination
my lords,
tests what?
my lords,
And that has been made,
my lords,
which you are reading.
my lords, aptitude,
Aptitude, understanding.
my lords,
Those are the things which are mentioned. So if that examination is being held to test what is mentioned
my
there,
lords,
and that examination is held by Indian Institute of Science, which is one of the most premier
my lords,
institutions of the country,
Right.
and then in coordination with 4 IITs, 4 or 7 IITs, and then under in collaboration with the Ministry of Education, and if the employer in that case decides that that score shall be a valid score, because
my lords,
wrong in it.
I would rephrase my submission in this.
Therefore,
My lords,
yes, we will see. Okay.
my lords, I would rephrase my argument, my lords, by only limiting the my lords, the selection to gate by way of, my lords, amendment to section rule 7 without touching rule 6, or without even my lords, bringing in my lords, definition, amendment to the definition section where, my lords, gate should be included as a valid exam. And what the definition defines, my lords, the definition section defines only commission. So therefore, these rules do not recognize gate 7 excepting by way of a amendment to rule 7. So the net impact of rule 7, my lords, is, my lords, amendment, virtually an amendment to rule 6, the eligibility criteria. So the rule that was published all along, and, my lords, the basic minimum criteria provided in the rules, of course, my lords, there is no, my lords, I am not even arguing against the proposition that you can test me by any standards. You can also test me by gate standards. But why deprive me altogether from the zone of consideration, my lords? Because the dean would say, and my lords, that gives me a right, that all citizens should get a right to compete and equality and opportunity.
That's right, you appear in the gate examination.
But I am already
in gate.
I am already a BTech. I am already a BTech and I am already an MTech.
That is the opportunity given to you.
I am already an MTech.
No, you may not be required to take the gate otherwise. But if your employer wants that you take the exam, then
the employer can prescribe any qualification. There is no.
No. What we are saying, we understand that it is not necessary to take the exam unless you want post-graduation.
The purpose of gate
admission.
is
That is not the purpose. That was done for that, to test them. But everybody else, because of the sanctity of the exam, the way it is conducted, and I think also that least amount of litigation also challenging those examinations. One of the reasons for adopting that, what I had read in the last case, was the number of litigations. They are unable to hold the exams properly, unable to do it periodically, and a lot of other problems for which they turn to this.
Today, the situation as on the ground, my lords, today, I'll just rephrase that, taking up from your lordships, taking cue from your lordships, my lords, what fell from your lordship, my lords, is this, my lords, today, the UPSC is virtually relegated to abrogating its function of testing.
Yes, that is one of the grounds that was said.
Gate
that
can
you
be,
can
my lords,
challenge on that
my submission before your lordship is gate can be one of the criteria. It cannot be the sole criteria in exclusion of all other criteria
No, that is
prescribed under the eligibility.
Other criteria you have to pass BTech.
Yeah, BTech is already there.
So then this is the second one.
That is nowhere prescribed in the eligibility, my lords. Rule 6 does not
So you
prescribe.
mean to say because Rule 6 has not been amended, so they can't do it.
Rule 6. So you have to bring in an amendment of Rule 6 also. Corresponding amendment to Rule 6. And you have to bring in a corresponding amendment to the definition clause to read it into that. Otherwise, my lords, what is happening is, my lords, the eligibility criteria gives me, foists a right in my favor, a vested right, by and a amendment of the Rule 7 takes it away.
Mr. Palit, your
My lords.
point could have been that if a body, any private body,
My lords.
holds an examination which having its abbreviated form, gate, like any private
My
heat,
lords.
heat holds an examination,
In an abbreviated,
general
lords.
and whatever, A for something, T for something, E for something. And he says that this. So because that gate has not been defined under the rules, so any qualification, this don't say gate means gate, gate means that, or gate would mean the one.
My lords, I am
No,
thankful to your lordship.
gate is so well known that it's not necessary to include it in the definition clause. So is it your case that if they say gate, nobody is able to understand what the examination
No,
is?
that's not. My case is that the rules do not recognize gate.
See,
that is again.
that is again, gate means, you are right. Gate, even when you say government, it is stated government of Odisha.
My lords.
It means service means.
Government is not a state government. State of
Even
even, my lord, even the General Clauses Act does not define gate. So this is like a
all right,
entity which has been foisted.
all right, we will take into.
Months.
Yes.
I'll file a short note, Manats.
Who is for the?
Okay.
So, Mr. Mohanty, yes, so Mohanty has already made a.
Mr. Mohanty, yes.
Has submitted.
The government's role is the challenge. So UPSC has no challenge.
In respect, tomorrow I can complete tomorrow.
Tomorrow.
Same position, madam, but first hour.
I beg your pardon. I have filed an I for intervention. That is at flag C, my lord.
We'll see.
We have all the
Intervention are there.
Assuming the order of the single judge, when statute is there, it is not declared by arrest, so you should not pass any interim order not to declare the result. That is because we are the best candidates and we have get high scores in gate. And insofar as the question that those who have not appeared, suppose somebody who has passed.
All right.
I will
See, even if you say something, that will not prejudice our mind.
All right. Will assist the government, they have the competency to.
I have also appeared, so but other two petition I applied for intervention. And in this case also I filed a petition for intervention. Whatever document they relied upon or they referred to, if there will be that will be short.
No, they are not relying on any document.
No, they have the petition were collected.
It's a bunch of
Bunch of documents
that you can get. That we will ask them not to supply.
All amendments will collect it there. There is no problem. We'll collect it there.
No, you can.
Apply online also.
They filed it.
There is no question of applying online.
Take it from me. All the documents are here.
That is another point. We are initially when we
Those are
paper. Now you are bound to go through this digital. It was never we thought of then now we are a different class because we are not able to.
So I'm not so rigid.
No.
But if it is there, means I can collect it. There is no problem.
No, those are statutory provisions.
Employee is the master.
Statutory provisions means
Statutory provisions, nothing else. Since they are challenging the virus,
Yes.
we shall see the statutory provisions, and the judgments. You must be having the judgment which has been delivered by.
citation and all these things, man, I'll collect it there. Once I have on my own arrangement, I'll collect it. So, I'll collect it there.
And
Because we are the
thing-
intervener.
There are 2-3 aspects
Yes.
you can
Yes.
for the state to answer. Effect of absence of the definition of gate in the rules. 1. 2. Application of state civil service. Whether you have state administrative service different from state
It
civil
is
service.
medical services or the
All right, because that is strongly relied on that. And thirdly, and most importantly, whether the candidates have, before framing of the rules, were given enough opportunity to participate in the examination. So these are the
These are the 3 important aspects, my lords. Rightly, my lords pointed out all these 3 points, and that I think that is the very important aspects, my lords.
My instruction is all of them have appeared the gate long since, and some of them have appeared in the test itself.
my
They are now
information-
questioning the virus. Mirasri have taken instructions.
Yes.
They appeared the
That is
examination.
additional.
they might have appeared,
Yes.
but they might have appeared for the purpose of easy examination half-heartedly.
No,
All right.
Had
That-
they been knowing that this qualification is going to be a criteria, rather a qualification for
Enter into the recruitment.
employment in government service, they would have been more serious.
That is in,
You don't know.
since 2021 it is there. Okay.
Background is different, I will place background.
Mr.
Hundred
Mahan.
institutions who have wake up, Mala. Private education.
All right, let them submit, we will have a
Yes,
chance
yes.
of reply.
You will have the chance.
But I was only submitting, can it be any other day except tomorrow?
Tomorrow they will.
Tomorrow, I have to listen to the state, my lord. I have to, without listening to them, I can answer. I have to
No,
listen.
we will make you available his argument, their arguments.
That I can gather from the others.
No, you can answer on another day.
No, that is available on YouTube also.
I will be on the code.
That is our problem. We are not able to do that, Mala. Therefore, we are a class.
But Mr. Mishra, yeah,
No, that
junior
is there.
Mr. Mishra is
So
there.
I am
that is-
concerned. So I am concerned.
He's there to
I am
assist.
very poor.
take help of
I am very poor.
Senior counsels are not supposed to do that. They will assist.
That is why I take her help always.
Exactly.
So now they can say that we cannot do practice because we are not acquainted with this digital.
No, you are senior counsel. You have people to assist you.
Yes, next.
It's fixing it to tomorrow at
This matter, retaining its position.
Yes.
Much obliged.
चलो फिर डेट लेता हूँ
Test admission item number 6.
May I please your lordships? That all this is writ appeals will not arise out of the common judgment will not, that is judgment dated 24/2023, passed by the Honorable Single Judge in WPC OSC number 1071 of 2017. Well, the present appellants, well, they were initially appointed by a service provider, through a service provider as statistical field surveyor, primary worker, and investigator, my lord. Thereafter, my lord, in the year 2015, an advertisement came off, which was, my lord, published by the respondent number 5 for direct recruitment, my lord. That is by Odisha Subordinate Staff Selection Commission. And that advertisement not given effect to, which was under Annexure 5. Thereafter, under Annexure 6, another advertisement that was published below. And the present appellants, my lord, as petitioners, challenge those advertisements before the state administrative tribunal with threefold prayers, my lord, to quash the impugned advertisement. Second, to allow them to work as such in their respective post. And third, to regularize their services, my lord. After the abolition of the state tribunal, my lord, the cases came to before this honorable court and registered at WPCOAC number 107 of 2017 and other writ applications, my lord.
And counsel,
my lord,
you were appointed by whom?
My lord, we were appointed by a service provider, that is
Service provider.
my lord.
Whether you were appointed under 2013 rules.
My lord, Honorable Learned Single Judge has been pleased to hold that we are governed by the 2013 rules. And in advertisement,
you are not governed by 2013 rules. And therefore, your case could not have been considered.
With great respect, my lord, Honorable Single Judge has held that we are governed by the Rule 4, Category 2nd of the 2013 rules. And as in the advertisement, Rule 8 has been taken into consideration. The relaxation will be given to this kind of employees, extra mark and relaxation of S. Therefore, there is no scope for interfering in the impugned advertisements, as well as there is no relationship between employer-employee relationship between the state and the present appellants, my lord. The lordship may kindly see the impugned judgment, which is at Annexure 10, my lord, page 66. But your lordship may, the judgment runs from
When
page
were you appointed?
70. We were appointed in the year 2014, my lord.
2014, before, after rules came into force.
My lord, my lord.
So therefore, you don't fall under category 2.
Your lordship may kindly see.
Category B, category 2, you don't fall under this category because it says existing contractual employees. So you are not existing. 2013.
My lord, your lordship may kindly see page 77. Page 77 of my lord's brief. Rule 4 has been taken note of by the learned single judge. Rule 4 of the 2013 rules leads two categories of existing contractual employees as follows.
Existing contractuals.
Existing.
So you were, whether you were existing in 2013 or not. So it does not mean that all the persons who are appointed through outsourcing, they shall also be covered by category 2. That is those who were existing. You were not existing.
But in category 2, my lord, next page, it has been mentioned that contractual engagements made through manpower service provider
Please,
agency.
please try to appreciate this. Rule lists two categories of existing contractual employees. So you were not existing. We are again repeating.
My lord, because at the time of framing, rules were not in his service.
Therefore,
my lord.
So 2013 rules took into account those who were working and those in category 2 also, those existing. You are not existing.
My lord. And second, your lordship may kindly see, but in the advertisement itself, my lord, under Annexure 6, this rule has been resorted to by the state itself. By the respondent number 5, your lordship may kindly see. Six is the, my lord, advertisement dated 11/11/2016. It runs from page 27, my lord.
Yes.
Page 28, your lordship may kindly see.
Yeah.
II, my lord. However, in service contractual employees engaged directly or through manpower service provider in any organization of government of Odisha who were below 45 years of age and completed at least 1 year of continuous service as a qualifying date can also apply for the post age provision of the Odisha Group C and Group D post contractual appointment rules 2013.
So you can apply. On your absorption, these are two different things.
My lord, But my lord, there is another rules which has been framed by the government of Odisha in planning and coordination department, my lord. That is the rule, my lord.
You are in planning and
Odisha
coordination
subordinate.
department.
My lord,
You are working in planning
and coordination department.
you are working.
Now we are not working, my lord. Now we are out of service.
Then
Lord, with great respect, my lord.
So Nanda, which provision did you refer to just now?
My lord.
Which one?
That is
28?
page 28,
Yes,
last paragraph, my lord.
last paragraph. However, the in-service.
Contractual employees engaged directly or through manpower service provider in
What
any,
is it? What is in-service?
my lord, who are continuing in service. But Laland single judge has also had that this can be resorted to, my lord. As there has been 2013 rules. Great respect, my lord. If your lordship will kindly see, there is a separate rule, my lord. Odisha subordinate statistical surveyor method of recruitment and conditions of service rules 2015. My lord, that talks of, my lord, direct recruitment
Everything.
and not appointment through contractual basis, my lord. Because 2013 rules is on mainly on contractual basis and outsourcing employment, my lord. And after 6 years of continuous service, they will be regularized. But these 2015 rules, my lord, it never talks of any contractual employment and only talks of
so what do you want? Your grievance before the London Secretary.
But to before the, my lord, writ application, we have threefold prayer to for passing of the advertisement, my lord,
On what ground?
and to allow us, my lord,
On what ground?
because one sort of contractual employees, they cannot be replaced by another set of contractual employees. And there should at least be direct recruitment.
One set of contractual employees can be replaced by another set of contractual employees if the second this thing is taken through a process of selection, or if there is some change in the qualification, or if there is some process change in the process, that can be done.
Madam. What are our humble submission before your lordship is that as we have been continuing, our service careers was unblemished, certificates were given, and even the government also asked for information, my lord, annexure, I have, my lord, annexure.
Now, this is not our duty to convince you, but we are doing that. You were appointed advertisement?
No, my lord, before.
Without advertisement?
A letter was issued by the government to the service provider to provide employment.
So whether service provider had issued any advertisement?
No, my lord. Test was selection was there by the service provider.
So selection, you selected people and you came.
My lord.
You joined. Now they decide that they will have a recruitment process.
My lord.
And therefore that is not impermissible. So your submission that one set actual employees cannot be substituted by other sets, that is not acceptable in this case. When they are going to have a recruitment process full-fledged, the appellate.
Yes, Lordship may see that but he is submitting that a contractual employee cannot be substituted by a contractor. This is not his case. Yes, Lordship may see that 2013 rule MCML page 60, my lord, your Lordship may see Annexure 9. Lordship got it. Lordship may see the rule 5. Page 62, ma'am.
Yes, new recruitment policy.
Recruitment to the post shall be made on the basis of the previous provisions of the relevant recruitment rules or executed as the case may be in force, notwithstanding anything contained in the relevant recruitment rules or executed as the case may be in force. All appointments pursuant to sub-rule 1 shall from the date of commencement on contract basis. So, well, it came into effect from 12/11/2013. All regular appointments were made on contractual basis in view of this rule. So they were appointed through outsourcing agency, and they are not the contractual employees that to be covered under this rule. And we are not substituting them as if again appointing on contractual basis through outsourcing agency. This is a regular recruitment process, and these are the regular employees.
Yes. All right, we don't find any merit.
That is the matter that medical shops inside the campuses. We are filing an affidavit, my lord, today. We have already scanned it, but we are going to file it today. Copies may be circulated to.
Have you served copies?
I'm going to serve, my lord. Well,
It is stated by AGA that affidavits on behalf of the state are going to be filed today. By tomorrow. By tomorrow. After serving copies thereof online council.
Yes.
Representing the parties. So list this matter on 1 week.
Can it be after 16th? Can it be after?
holidays are coming.
All right. 20th.
Interim order to one.
Interim orders may cut.
Item number 54.
Yeah.
The petitioner before your lordship was previously blacklisted. Now, he contested the blacklist and his stand was vindicated by your lordship by a judgment delivered on the 22nd of August 2023. But despite quashment of the blacklisting order, they took 4 months to unblock the portal. And even after the portal has been unblocked, and he has subsequently participated in other tenders where he has emerged successful, he is not being the tender for which he is before your lordship. Now, if I may take your lordships to the your lordship may kindly see annexure 3 at page 90. I have listed out 6 tenders. Now, even though I was successful in these tenders, the tenders were either cancelled for reasons after I had become successful in them, and some were denied to me because of the order of blacklisting. Be that as it may, my lords, this honorable court, by the judgment, your lordship may kindly take that judgment, which begins at page 91. Page 93 it begins. Your lordship may straightway come to
Just come to page 90.
90. Yes, my lords. Yes, my lords.
Come to item number 3.
Yes, my lords.
So you were L1 in this case?
Yes, my lords. I was successful.
So in all the cases you were L1?
Yes, my lords.
T4, 5, 6?
Yes, my lords.
File your affidavit, please.
My lords, in fact, 3 occasions they have taken time to file their reply. This was on 17/5/24, on 19/6/24, and again on 2/7/24. On 3 occasions, they have taken time to file a reply. No reply is forthcoming, and possibly they cannot have any response to this, save and except saying that they have filed a SLP against the judgment of the High Court, wherein no interim orders have been granted.
Let us see. Let us see.
My lords, in fact, the SLP, there were series of defects therein. They cured the defects.
We cannot comment on that.
That's true, my lord, but there are judgments of the Supreme Court which say, and your lordships also in a series of cases have said so, that unless and until a stay is granted on the judgment, they cannot deprive because
we understand. We understand.
And my lords, this is a question of my fundamental right.
That we understand.
Guaranteed in Article 91, and they are depriving me my livelihood.
So we don't know what stand they will be taking in their counter affidavit. So let them file counter affidavit.
Your lordship may grant a short time because series of adjournments have already been they have taken.
Price. Opportunities were granted to the state opposite parties to file counter affidavit. So strong. Till date, however, no counter affidavit has been filed. So stop. By last indulgence. Time till 22nd is allowed to file counter affidavit subject to payment of cost of ₹20,000 to be deposited in the account of advocate. Yes, do it.
Lords, just one more prayer. I have shown to your lordship that I was successful in 6 tenders, and they have ultimately cancelled those tenders to deprive me even after I had successful. Let them not cancel the present tender in the meantime.
Not.
My instruction that we have not cancelled, my lord. We have taken
the question.
My
The biggest question is that you are not filing counter affidavits.
My
So this time we have passed the normally, if you don't file, you have the liberty to file counter affidavit or not to file counter affidavit.
normal file counter.
But if because you are a state, you will have to respond. If you don't respond, we may impose cost. Don't respond, even then we may initiate contempt proceeding against you. All right. Because this is state.
Problem.
Item number 55.
Last occasion, your lordship had asked my learned seniors to tell a date to your lordship that the online forms can be submitted.
Not that NOC matter, where deficiencies were submitted, most of the cases bilateral stage, and only there are 5 to 6 cases he has pointed out. Within 14 days, they have submitted, not hard copy. You, my lord, wanted whether we can give them only for them, whether we can get a date for them for submitting online. In that case, I have got the instruction if those within 14 days they have applied on hard copy, we will allow them 1 day to submit the copy so that we can cover. We can allow them to use.
So you come out with a decision. Otherwise, you are saying it tomorrow. You can say no.
I will.
Tomorrow you come out with a decision.
Yes. Only those cases we will do.
That seems fair, like in the other decision. Okay,
My
you
lord,
do it.
in all this nursing matter,
See, you are distinguishing cases of such institutions.
yes, yes, sir.
Which file hard copies,
Yes, ma'am.
where they required to file hard copies.
In the office, no, we have got only a online, they have to give an online.
Online. So your online was not functioning.
That's their allegation, but online people have already submitted. And online we have received so many cases and we have allowed their inspection and everything. Now they are giving a seal and telling that we have submitted online. And this is the proof that we have submitted. Because my lord want, because that day I saw you.
Tomorrow with your decision, we'll dispose the case along.
So you are saying the persons who have applied offline, but within the date,
Yes.
them you will give a chance.
Yes. My lord, our other cases are 3 varieties of nursing matters are there. There is a variety is there that we had given them time for online inspection. The allegation they have come up, election was there, that's why we couldn't.
That we will not accept.
That's the only thing.
That we will not accept. Election, the
Inspection.
that is not acceptable.
No, my lord, in one of the cases, that last 2 items in that, there they have given the reason that there is another writ petition pending where we had sought for the inspection.
That is.
Which case?
My lord, that is, lordships would see that 18000 and the other one is 18003, I believe, my lord. 18003. The reasons they have given is matter is sub judice and WPC number so and so and so and so. No other reason, because in those cases we said we have submitted, kindly inspect and do it.
Submitted.
The reason they have mentioned in their order is that pendency of the writ petition.
My lord, because these matters are pending, we have not given it to the only thing is that whether he has submitted online in time of that is we have to see and give. If the deficiencies has been submitted in time.
All right, first of all, you come on that.
Yes, ma'am.
Take a decision. We'll
Yes.
also proceed step by step.
Yes, ma'am.
It's also check up so that you can answer.
My lord, in item 24 similar matter, you lordship. In the first hour I have mentioned, your lordship said that at the time of the receiving you mentioned. This is the covered matter, lordship. Your lordship already has pronounced the judgment, deleted stage of NOP.
My lord, I have got a list wherein I have got the original writ petitions which are covered by minor judgments. And that list I will provide so that can, and those cases who are covered with 14 days delay and who are not in others.
That
Then-
was given.
Yes, and also there is another 2-3 cases where inspection has been done. The principal's qualification and principals was not present. We have not accepted. 2-3 cases are there.
Yes, you have right to do.
They can subcategorize everything, my lord, in different.
I have done it.
Separate memos, then give
Yes,
the list.
yes, I will give it. So that tomorrow let it come at 2 o'clock.
Lord,
My lord, item.
today's 24 can also be tagged along with that.
22 also.
My lord.
So here's.
I will give all the matters tomorrow. Yes, ma'am.
So
My
24,
lord-
there are a number of cases.
Yes,
So
ma'am.
which
Yes,
one?
My lord, in
24,
24,
there are 20 cases.
yes, ma'am, I have got all written everything.
So all these can be
Yes.
tagged up. 24 can also come along tomorrow
Yes,
along
ma'am.
with this 55
But
and
these 3
57.
matters, that is pharmacy regarding pharmacy fire certificate, I want to take time and file counter.
Which are those 3?
Last three of 24.
So those last 3 matters I'm appearing, my lord.
Yes, ma'am.
There it's relating to renewal. Last year they inspected and granted us fire certificate. This year for renewal, they are saying that you have to, it was rejected by a common order. So about 13-14
I will give a
colleges,
counter to it.
3 are before your lordships. So it's relating to fire safety. We have all the requisite norms, but for next year they are saying that we will not renew.
My lord,
They renew because they want a fresh certificate or what?
So fire safety, normally they don't give any timeline
Huh.
unless there is deficiency. Unless there is otherwise deficiency.
my lord, yesterday I have got the copy. Yes. So I have to get instruction at least 1 week.
All right, tomorrow we will take up
Other matters.
these matters.
Yes.
Including 24.
Another 3 matters, sir. We are in the list 24 item you will see. Matter of WPC number.
Mr. Your matter will be taken up tomorrow.
Yes.
That matter will be covered matter.
I will give the list.
Some of the matters are they are due to fire certificate. If they have rejected my application after initiation. But my respectful submission before Lordship. Already this is a case.
You are arguing which case?
Item 24 matter.
So will you give also to an opportunity to address or reply to your subject? So we don't know whether the counsel for DMET nor both of us know about your case. So let it come tomorrow.
Subject to your lordship.
Yes.
Subject to your lordship consideration. These are all matters relating to pharmacy, either renewal or not. But if possible, Learned Council make a categorization.
Yes, yes, I have done it.
That is what he's saying.
That would be heading is that can be
Mr.
separate.
Mahathir,
I have done it. I
if
have
the
done it.
categorization now, the list
Yes.
it can come.
And
Can
the
be
list-
separately.
Tomorrow I will categorize. I have got this today. Tomorrow, today I have
No,
got.
no, I'm saying if you give it today, they
Yeah.
will list it
Yes, yes, yes.
separately.
He can
Yes, yes.
separately and principal.
Yes, yes, yes.
So that your lordship can take it. That will be convenient to your lordships.
I have already prepared them.
Oh, you have already categorized.
Yes, my lord.
Very good.
Heading on chhi
Item 22 and 26 of
Heading on
question. Item 22 and 26.
So Mahathir, please write which is what type of case.
What?
All right.
I have already given everything.
Yes, yes.
57, which is
One,
I have given everything in writing.
4, 5.
Add one more column.
Yes, yes, my lord.
one more.
Add one more column.
Yes, my lord.
That whether you are permitted. You will permit or not.
Yes, yes, my lord. Why? How?
But may I just make a small additional claim? Lord? Item 57, the top matter is something to need to clarify. It's permitted to withdraw. We just want to withdraw.
Which item?
57, number 1.
Nityananda College of Nursing.
Number 1.
22 and 26 may also be added to tomorrow.
That's what I have done.
That's what he has done.
Yes, I have already done.
Tomorrow at 2 p.m.
Yes, 2 p.m.
Yes.
Just a minute, 57, all the matters withdrawn, or only your matters?
One.
Only one.
First one. Okay.
First one, Nityananda.
Do that extend my senior advocate bench, I have to file a memo of withdrawal.
Okay, please.
Just enforce.
Keep it on record.
Oblige.
Item 20, 22 and 26. That is item 54. So 55.
57.
57.
All is tomorrow.
24, 22.
24,
22, 24,
26.
55, 57.
55, 57. All to be a single man.
Yes.
Single na alga alga kari apra deyandi ante.
I have given it.
And I have to check all the case numbers are there.
All these are there in the list.
Yes, yes. Today's list is all this are there.
Alga alga kari
Three.
I think categories.
Yes.
1, 2, 3, 4, 5, 6, 6. I have 6, 7, 8. Category, how will you do? Different serial number?
8 serial number.
Huh.
Making one number as in reading this.
Out of that 24 items, 2 matters will be covered. I have given.
That is, I have given that to delete it. You will
Out
delete.
of that 24 matters.
Those were covered matters I have mentioned. Those should not be taken out.
Covered matters were mentioned.
Yes, yes.
All right,
Mentioned,
all the
I have
matters will
mentioned.
be.
Yes, madam, I have mentioned.
First lot is covered, I think.
No, there is 4 to my matters, which is I have written. And will
You've
tell,
written covered?
yes, I have. OJC number also, WPC number also I have given.
Where have you mentioned covered? Or covered or whatever, similar to so and so.
Second page, my lord. Belated grant of NOC, that 4 matters. 4 matters. Second page. I have given it. I have given that.
All right.
In that item 24, what that consolidation matter only that.
Item note 24, that consolidation matter has been wrongly tagged, single bench matter.
We have understood.
That may be separated.
It's placed somewhere. Report that Nandini Patro.
Yes, fine.
Some other matter must have stayed.
Item number 7.
Though there is a delay of 200 days.
How much?
248 days. But your lordship observed that the delay will be considered at the stage of admission. My lord, the issue with respect to grant of study leave.
Staff nurse.
Staff nurse. But the brief fact of the case, my lord, I have prepared a stop there.
Last occasion, your lordship, directly I filed an affidavit stating that similar matters, those who have granted study leave along with me, their cases has been considered and study leave has been granted with full pay. I have given affidavit to that. Lordship last one directed the instruction with regard to my affidavit earlier filed.
Have you filed?
Affidavit not filed because the order, the last order, if your lordship will see, only Mr. Misra was there. So it was not within my knowledge. If I am supposed to file an affidavit, then your lordship. But the issue is a contractual appointee went on study leave without sanction of government. Later, his service was regularized. So now the period of service he has undergone for study leave, whether for that period he is entitled for the benefits. That is the sole issue. Now, the case of the petitioner, my lord, pursuant to a government notification, a selection was conducted to select the persons to go for. The case of the petitioner appeared before the selection committee, found suitable by the selection committee, but this at that stage, his case should have been recommended to the government, and the government should have passed an order of sanction, granting sanction to go for study leave, and then she should have marched for study leave, and for that period he should be whether he should be entitled for benefit or not. But here, only after the selection, by the recommendation of the director, the superintendent of MKCG Medical College relieved the petitioner allowed to go for study leave.
Because she came to the High Court.
And she approached the Honorable Court, and by virtue of the interim order passed by this Honorable Court, she was allowed to go for study leave with a rider that in the event the writ petition is dismissed, she will not claim any equity. Now, that writ petition was subsequently dismissed as infructuous, and petitioner was granted liberty to approach the authority by way of a representation. Now, considering that representation, government treated that period of study leave as extraordinary leave, because on the date the petitioner went for study leave, she was not a regular employee, she was a contractual employee. So, your lordship in this case has to examine
Rule 179, Rule 180. Rules code, my lord.
And Mr. Das, another doubt. The two staff nurses on which case he places reliance, they were appointed along with the petitioner, but they have gone on study leave subsequently after their services were regularized. Or am I mistaken? Because they were regularized in 13. Study leave they have taken 2020-22.
No, here.
No, not here, there. On the two nurses on which Mr. Swine says that they are similarly placed. No, that it is there in the rejoinder. I am reading from that only.
But rejoinder, but so far as the persons, those who are allowed to go on study leave along with the petitioner, 4 persons, all of them have been treated equally. And those orders are there, my lord.
No. Rejoinder is given to, sorry, affidavit. Affidavit with with what date?
Date. Affidavit with date.
What are they writing? Date taptation? Yes, page 11 of the affidavit. Relying in the cases of Srimati Sanghamitra Das and Srimati Banisri Pradhan. They have been granted leave 16/1/2020 to 15/1/2022. And the services have been regularized in the year 2015. The effect from 2017.
2020, there was a separate circular. But so far as these petitioners are concerned, this particular respondent is concerned, our case was considered in terms of a 2013 notification, my lord.
Then you have not looked at these documents.
I'm sorry.
So what was the post with the
Post staff nurse, contractual man. Initial appointment.
So it is a subordinate service or what? Please come to Rule 179.
179. Grant of special study leave.
And then come to note.
My lord.
So what is this? How do you define the subordinate service? Okay, if there is subordinate service, then there must be superior service.
Yes.
Whether it is subordinate service or what?
No, regular service.
So lordship, look at clause A of that 179. Clause A. Subject to the condition here it is specified, the government, the state government may grant special study leave to a government servant to enable him to study scientific, technical or similar problems or to undergo special course of instruction. Such leave is not debited against the leave account. Now, my lord, here two
Leave must be granted by the state government. This is your submission.
one is leave must be granted by the state government. The next is should be granted to a government servant.
Government servant.
So a person who is in contractual employment can be termed as a government servant.
Yes.
This is one mile. Now, number 2, your lordship may kindly see B. These rules relate to study leave only. They are not intended
to meet the case of the government servant deputed to other countries, so and so. But I'll start after that rule 59 as it is referred. Such leave may be granted to a government servant in the public health, where public health, civil, veterinary, agriculture, education, public works, or forest department, or to any other government servant to whom the state government is of the opinion that the leaves should be granted in the public interest.
Yes.
Then, your lordship may kindly see rule 180. 180. Extra leave on half average pay for the purpose of study leave may be taken either in or outside India. Then this line is important, my lord. Study leave will not ordinarily be granted to the government servant of less than 5 years service, or to the government servant within 3 years of the date in which they have the option of retirement. So, a person or a government employee who has at least not rendered 5 years of service, he shall not be allowed to go in for a study leave. Or a person who is only due for retirement, 3 years due for retirement, he will not study leave. These are the two options, my lord, available, my lord. Then, now.
So this is the only provision for study leave.
Study leave. Now, my lord, here what has happened?
Now you should first come to rule 2.
Rule 2, my lord. I'll take your lordship to the list of dates.
No, rule 2 of the Odisha Code, Odisha Service Code.
Rule. Yes, ma'am. The code shall apply to all persons appointed to public service and posts in connection with the affairs of the state.
So these rules apply to them only.
Yes.
Those who are appointed to public services and posts in connection with affairs of the estate. Affairs of the estate does not mean these contractual employees.
Yes, my lord.
All right.
Yes.
So if this is one aspect, and then and therefore it is mentioned in 179 that members of subordinate service cannot be granted this leave.
Yes, ma'am.
Because they are not holding the posts in connection with affairs of the
state.
All right. So this is the background in which there is 179.
Much obliged.
So therefore, the study leave will not apply in his case. Study leave will not apply. So that should be your.
That is the basic submission, my lord. Apart from that, so far as facts of the case is concerned, my lord, looking into the list of dates, the lordships will find that the period when the petitioner was allowed to go for study leave, there was no sanction of the government. Only she appeared in a selection, and pursuant to the order of the nursing, she was sent on study leave. She went on her own risk, my lord. Now, she was issued with a course completion certificate. Then subsequently, her service was regularized, keeping in view a government circular, and that too from a date. If from that date your lordship will count the date for study leave, it is only 8 months. So there is again non-conformity with 180 because she had not completed 5 years of regular service.
That is not the question. The question is, as we have been able to understand, that whether service code applies or not in the case of such employees. That is the fundamental question.
Yes, ma'am.
Most fundamental. That's all.
That's it.
Yes.
My submission is also kindly see the submission made that
So you went on a study leave.
I went on a study leave 5 years. Government has decided go to selection committee was constituted by the government. A circular was issued that is annexure 50. Government, as per the government relation, they said only 4 persons selected out of the staff nurses, BSc staff nurses, and those who will be selected, they will be allowed to go on study leave. Accordingly, I applied. I was selected. Thereafter, when study leave, I applied for study leave. My study leave application was kept pending on the ground that your regularization matter is still pending before the government. Till today, your regularization order has not been issued. Therefore, I have approached this honorable court saying that neither they are considering my regularization nor they are granting me study leave. Therefore, this honorable court directed you to go on study leave, and in the meantime, you also consider his case for regularization. And I went on study leave. Study leave was granted. I went and pursue my study. When I was pursuing my study, this leave was granted. My service was regularized from the date when I completed 6 years of my service. So that is much prior to that grant of study leave. So after completion, I again came back and joined in my earlier post as a regular employee with effect from the earlier date when I completed 6 years of service. So I became a regular employee from the 2015, much before I went on study leave.
So on the date
So-
when you left,
Yes,
on the date when you at your place for earned leave, whether study leave,
yes.
whether you were entitled for a study leave or not. That is the question.
I was entitled because my application, I should have been regularized from the 2015, but they kept it pending, clashes with the government. Therefore, I have challenged. And this honorable court directed that you go and take study leave. According to the granted,
Your services ought to have been regularized in 2015.
my service ought to have been regularized from the date of 18 to 2015. They kept it pending, 2015.
Your
I went on study leave on 17/11/2015.
17/11/2015.
15.
You went on study leave.
Yes.
Then
My service was regularized much prior to that in February, that is 18 to 2015.
18 to 2015.
Yes. So I was a regular employee. The submission is wrong that I was a regular employee at that time.
Mr. Swain,
Being a regular employee, that was granted. And
when was that regularization order
and
passed?
since this dispute government has regime, a resolution, another resolution under Annexure 12, government has clarified whether that service is to become Annexure 12.
Mr. Counsel,
Government
we also
clarified.
have a right to be heard.
Yes.
We at times also have a right to be heard.
Because if the question goes unanswered, that doubt will remain. On basis of that, we'll dispose of your application. I've been asking you on which date was that order of regularization passed?
Date of order of regulation, Annexure 6 months. Order of regulation passed subsequently. That
Order of
is,
date of
yes,
regulation.
Annexure 6 months.
Annexure 6.
Yes.
So which year? Annexure 6.
Um,
Month is mentioned.
yes, it's
Date is mentioned.
Everything.
Annexure 6 is the leave application. Order is, that is 27/7/2017. 27/7/2017, that is page 13, Annexure 5. Page 13 of my leave application. Page 13.
So this regularization was done from retrospective effect.
Yes, with effect from 18 to 2015.
All right.
Yes,
On 18 to 2015, you were
a regular
a regular employee.
employee.
But there are two facts which are not in dispute. That study leave is granted under which provision?
179 or 180.
179, 180. So 179 only government can grant.
Yes.
So the government had not granted.
Government has granted minutes. Annexure 6.
What is the
Annexure 6 is state government, Government of Odisha Health and Family Welfare Department. Annexure 6 is the study leave granted from 17/11/2015 to 16/11/2017 and treated as EOL, extraordinary leave. That is what I am challenging. That government has granted study leave, treating it as extraordinary leave. That is what I am challenging. That government should have treated it with a regular pay. That is what I am challenging. I am challenging the action of the government. The person, those who have regular, they have been granted in the same order. Answer page 13, answer 5. That name is Banishri Pradhan. She was regularized with effect from 27/8/2015. She has been granted study leave with pay. But in my case, they are not granted.
Mr. Swami, when did she go for study leave?
Study in 2020.
After she was regularized?
After all also I have gone.
No, you have gone in 2015.
Question is that my case was pending before the government and this honorable court granted interim order. That's the difference.
No, but both of you have been granted simultaneously at the same order.
Simultaneously.
Same
Yes.
order, but they went after
She was not selected at that time. She could not go. I was selected.
Both, but she has gone after her services were
Yes.
regularized.
Question is when she was selected. I have applied. I was selected. Government has selected me. Thereafter I have gone. So all actions by the government. And that has also been clarified that 5 years period, my contractual period is also to be taken into consideration. That is the clarification under Annexure 12(7). That they are not obeying. I'm surprisingly how they are not obeying. I'm placing it below 12. That government circular that with regard to perusing higher studies by in-service nursing personnel. In continuation to this department notification dated so, after careful consideration, the government have been pleased to allow the past service of the staff nurses,
All right.
those who have already been regularized.
Even if we accept your submission,
My lord.
that you ought to have been treated for all practical purposes, a regular employee as on 18/2/2015.
Yes.
How do you say that you are not a member of subordinate service?
I'm a regular employee. I'm a regular employee.
Employee is PM is also a regular employee. So whether he can be granted study leave in exercise of that power.
They are, that's what I will check. They are granting to all staff nurses.
Maybe granting, now a legal question has arisen.
That I will check up. That part I will check up whether that how they are considering. But they are not only from 2015, they are granting from 2009, 10, 11, all annexes I have given. Right from
Be given, but see.
yes, I have given. They are going on granting. But only discrimination.
We are trying to find out the source of power.
That they can say, Lord Smith.
Huh?
That they will
Yes,
make,
they can say.
because they are
are
granting since
saying,
2009, 10.
They are saying they are referring to Rule 2. So the study leave can be granted only to such employees who are government servants who have been appointed
They are
in connection
only
with the affairs of the estate.
no,
So
they
you
are
are not in connection with the affairs of the estate. 1. And 2, you are member of subordinate service.
no, I'm not a member. I'll check up subordinate service or not. I'll check up.
Are you gazetted?
But the notification clearly staff nurses will be granted.
Is it a gazetted post?
Madam?
Is it a gazetted post?
Gazetted, I think gazetted. I think it is a gazetted post. I'll check up.
Gazetted post.
I'll check up. I think it is a gazetted post. I'll check.
Gazetted post, no appointment can be made to gazetted posts without the recommendation of the Public Service Commission.
I'll check that part, whether it is subordinate service or not. I'll check up that part.
Service, all the services are subordinate service other than those which are.
I put in that line, I'll check up. Only in the counter, they have only raised objection that I have not.
Counter. Now the law is before us.
But the Lordship is posing question, I will check up. Lordship grant some time.
Check tomorrow. No.
The Lordship next week. Tomorrow, lady will not.
Come tomorrow. Otherwise, that is the only question, legal question.
Take on Friday. Friday till Friday.
I request on behalf of the respondent, this matter on Friday. Tuesday.
Item number 8.
Next week. Next week.
You have please.
Here the appellants have challenged the impugned order under Annexure 1, that is order dated 1/9/2003 to 2023, my lord. Passed in WPC number 976 of 2013. Well, the facts are like this. But the respondent was allotted a flat under the scheme which was floated by the LIC, and the allotment, the draw in the draw, which was drawn on 18th of July 2010. And my lord, the allotment letter was issued, and he deposited the registration fees of rupees 50,000, and thereafter he was requested to deposit the first installment of rupees 14,63,000 by letter 25th of August 2010. My lord, he could not deposit and sought for extension. He only deposited 1 lakh rupees on 8/10/2010. And despite the reminders given to him on December 2010 and again on April 2010, 11, he didn't deposit that amount. So therefore, as per the terms and conditions of the brochure, the allotment of the flat was cancelled by letter dated 6/9/2011. And after cancellation of the allotment also, he went on making representation to the authority, to the appellants, saying that please consider my case, please consider my case. And then a letter was written to him on 20th of July 2012, saying that you can better approach the higher authority because we have already cancelled the allotment. Now, my lord, he challenged that. Against that order, he has come before the Honorable Court, and its prayer is that the cancellation letter which was issued on September 2010, that is not legal, and that the direction may be given for allotment of the flat in his favor. And the Honorable Court, referring to the terms and conditions of the brochure, clause 13, subclause C, had said that pursuant to clause 13, subclause C, the direction has been given that you better accept the balance amount with 6% interest. And my responsible submission would be that the petitioner, the respondent herein is by the terms and conditions of the contract. And as per the brochure condition, we have cancelled it because he didn't deposit the amount within the time stipulated. And we have cancelled it. And with regard to, the lordships may kindly turn to the impugned order at page 12. The learned Honorable Judge has referred to the terms and conditions of the brochure. As per clause B, in respect of allotees who decline the allotment or fail to allotment within the prescribed time, total registration charges of rupees 50,000 will be forfeited. Then clause C, in respect of allotees who have accepted the allotment of and paid the first installment but fails to pay the balance subsequent amount within the time stipulated, time schedule, as mentioned above, and as per the intimation of LIC, the registration demand refunded without any interest. In case any payment is not paid within the stipulated period, with or without availing loan, the allotment is liable to be cancelled. So my response submission is terms and condition of the brochure, we have cancelled the allotment. So the Honorable Court should not have invoked the jurisdiction vested under Article 226 to decide to intervene in the matter, because this is not a statutory contract. This is a terms and conditions of the brochure, and the parties are bound by that. Assuming that the court can interfere in this matter, then as per the terms and conditions, we have cancelled the allotment as per the terms and conditions brochure. The direction that you should hand over the possession and by taking interest at the rate of 6%, that is also not applicable because he has not deposited the first installment even. And to that respect, my lord, your lordships, I will be relying on the judgment of the Honorable Supreme Court.
Where is the brochure?
Brochure condition is, my lord has quoted in
Your Lordship may kindly see page 12 of the impugned judgment. My Lord has quoted it.
Yes. So he did not deposit.
Yes, my Lord. And as per
And what
clause
is
C,
court's view on this?
as per clause B, in respect of allottees who declined to the allotment or failed to respond to the allotment within the prescribed time, the registration charges of rupees 50,000 will be forfeited. In respect of allottees who have accepted the allotment and paid the first installment but fails to pay the balance subsequent amount within the time schedule as mentioned above, as per the intimation, the registration without any interest. But here in this case, he has not deposited the first installment. If he would have deposited the first installment, then the amount deposited would have been refunded to him with interest. He did not deposit it, despite reminders given to him. And in case any payment is not paid within the stipulated period, with or without availing loan, the allotment is liable to be cancelled. So my respectful submission would be that since we have, as per the terms and conditions of the contract, we have cancelled it, and this is not a statutory contract. And my Lord, as your Lordships know, the law has been settled by the Honorable Supreme Court in the case of Bareilly Development Authority and Ajay Pal Singh, 1989 Supreme Court. And that has been also followed subsequently by the Honorable High Court of Delhi and Allahabad. That in this sort of cases, the Honorable Court should not interfere, and because this is not a statutory contract.
All right, we will not interfere, but once the learned single judge has interfered, so where is the flat?
Yes, my
And
Lord.
what problem do you have?
My Lord, your Lordship may kindly see the interference. Why he has interfered? Your Lordship may, the analysis started from paragraph 18 of the impugned judgment. He said, since after cancellation, we have issued a letter pursuant to his representation dated 28th of July, that better you consult the higher authority. That means we have that has automatically the language is, my Lord, I am just placing for opinion. There is automatic non-operation of the cancellation letter issued by the opposite party number 1.
Paragraph?
That is paragraph 21, page 25, your Lordship. Impugned order. Sorry, page 14, running page 25, internal page 14. Because we have, after cancellation, he has been making representations. And we said that, all right, you approach the higher authority. The Honorable Court said, since you have written a letter to him, that has.
No, where is that flat located?
My Lord, that is, my Lord, annexure 12 to the writ application.
What problem do you have? Now, why fighting?
My Lord, fact remains is, there are similarly situated persons are there. Those who have also not deposited, and some also withdrawn that amount who have deposited.
So, but in this case, there is an order passed by.
There was an interim order in this case.
There was an interim
There was an
order,
interim
and
order.
Today, there is a final order. So, he had booked a flat. So, what is your response?
My Lord, this Honorable Court has completely dealt the matter from paragraph 13 till last, my Lord.
Where is the paragraph 13? Come to
13 at page 19.
Come to page 12 of the order.
Yes, my Lord.
Mode of payment.
Yes, my Lord.
And you satisfy us that you had complied with.
My Lord, I deposited amount. At this stage, my Lord, I would like to draw my Lord's attention about the brochure, wherein it was communicated that he can avail a loan from their sister concern, or they can take from the other establishment. I applied to the sister concern, and they assured and they communicated to the LIC that we are going to finance him. At this stage, my Lords, can have a look the mode of payment. I have deposited when there was a delay in payment by the LIC Housing Corporation. I deposited 4 lakhs, my Lords. I submitted a back draft.
They don't know their sister concern. Sister concern has different identity. It's a different entity altogether.
But in the brochure, my lords, they have indicated that, specifically they have indicated. My lord,
That is only also for the purpose of, enhancing the business of the system concerned, not for the, that does not amount to any assurance that you will be getting loan.
yes, my lord, that because that housing car, my lords, they communicated to them that we are financing.
So it's a simple question is that there was an agreement. You did not comply with the terms of the agreement. Then how can you be given the
My lords, I complied. I submitted. My lords, I intimated them that since there is a delay in their sanction, rupees I'm submitting as well first advance, my lord. That was not accepted by them.
Rightly,
My lord.
Rightly, they did not accept. Unless you satisfy that you complied with the mode of payment, you don't have any case.
My lord, the first mode, my lord, first payment, your lordship can have a look to paragraph 20 for a moment. How their lordship have dealt the matter. Starting from paragraph 20. Though clause 6, the court, however, while there is power with opposite party number 1 to extend the period beyond the stipulated period on covering of the grounds, there is also provision made in the case of deferred payment, delayed payment beyond the stipulated period. There shall be loading of simple interest of 6% per annum for the extended period. For the readiness of the petitioner preparing a bank draft, even prior to the date of cancellation, further for the correspondence of it dated 28/7/2012 by annexure 12, this court finds there is no doubt there is the case of the petitioner was kept pending consideration of at least till 28/7/2012 for the pleading of the both. Court finds there has been no further communication to the petitioner after the assurance given to the petitioner after annexure 12 on the operation of the correspondence of annexure 12 and in the information therein came to be existing. For the opinion of this court, their automatic non-cooperation of the cancellation letter issued by the opposite party now court.
What is this?
By the opposite party number 1, dated 6/9/2011, even after annexure 12 is issued, there is no further correspondence in the final communication of the decision of the corporation, even though there are
counter question of decision, you did not comply with the cancel. That's all.
My lord, sir, I was ready, even I am ready today with the entire amount that there is interim order passed. I am ready today to pay the entire amount at any fee.
Why? They may get more amount today for the flat.
They allotted me, I was ready.
They allotted you, you did not pay. So what right do you have?
And the Honorable Court also directed.
Resolving the.
No, if he pays the amount with whatever interest. Because here probably the court has said that 2 installments starting from that date. But if you get your money, he pays entire amount.
My lord, there are out of the entire block, there are around 21 flats in which dispute like this are there. So once here we have cancelled the allotment. In other cases also we have cancelled the allotment. Once in this case the direction is given to consider, then in other cases also we have to, because in those cases what I got instruction that they are going to advertise is again, because this was the price of 27. Sorry.
We can say what is the amount he is required to pay.
My lord, at that point of time, the cost was 27 lakhs.
No, at that point of time, 27 lakhs.
Yes.
Till date, he has not paid.
He has not paid.
So what, if you calculate, what would be the amount? So we don't want any loss to be caused to you also.
I will take instruction.
you take instructions.
I will take it.
Take instructions, we shall make it clear that this will apply to this case only because there was an interim order and plus he had approached, the others have approached.
There are three cases are pending.
Find out so that we don't differentiate between anything. Tell us
Because
also other
what my instruction is, those who are cancelled, they are also again going for fresh advertisement. The cost of which was 27 lakhs by then, 2010,
When
is
had
much
you-
more now.
When had you cancelled?
My lord, in this case, we have
11.
cancelled in 2010.
And others?
Others, I do not know exact dates, but
Thus, you had cancelled, if you had cancelled and you could not dispose them off.
I will take detailed instruction on that.
Flats still vacant.
You have gone for advert. It is different. Here, interim order you have not done. Na? So just
Here interim order was there. Interim order was there.
Seeks adjournment to obtain instructions. This was matter on 2 weeks.
Item 9.
My lord, may give me 2 weeks time.
Weeks.
Item 9.
May it please your lordship. Lordship, the petitioner herein is challenging the action of the opposite parties, your lordship, in forfeiting my EMD amount, which is illegal and arbitrary and against the principles of natural justice, your lordship. The petitioner herein is engaged in the business of power production, your lordship. It generates electricity by procuring coals, your lordship. In fact, the petitioner participated in a tender through various coal procurement programs, your lordship, by the opposite parties. The annexure to, your lordship, are the notices in which the special e-auction scheme is held, your lordship. That is for the.
So whether the affidavit has been filed on behalf of the respondent?
No, your lordship. The notices has to go.
Notice. Who accepts notice? Mahanadi.
Mahanadi Coalfields. Notice can go.
Obliged, your lordship.
1 week. 6 weeks.
Item number 10.
କହିଥିଲେ ଆଜି ଗୋଟେ ଡେଟ୍ ଦିଆଯାଉ କାହିଁକିନା ଲୋକମାନେ ବହୁତ ଅସୁବିଧାର ସମ୍ମୁଖୀନ ହଉଛନ୍ତି। ଇଭିନ୍ ମୁଁ ଦେଖଉଛି ବି ଜଣେ ଲେଟର ଗୋଟେ ଦେଇଥିଲେ ପଢି ଦଉଥିବି ଡିୟର ସାର୍ ଗେଟିଂ ଅଫ ଦ ଡେ
ଇଂଲିଶରେ କୁହନ୍ତୁ ଚିଫ୍ ଜଷ୍ଟିସ୍ ବୁଝିପାରିବେନି।
permission kindly permit me to speak in Oriya.
Yes, we are will let the matter go out of our list.
এই যেটা আপনাদের ফাইল করছিল
Just a minute.
বহুত লোক
The
মানে
matter will go, Mr. The matter will be listed before a bench where both the members know Odia. All right. For appropriate bench after obtaining order from the Chief Justice.
Item number 11.
In this matter, consent has been given, my lord.
What?
Consent has been given by us, my lord, in this matter. Item 11.
Client has taken the file.
Yes. My lord.
And counsel appearing on behalf of the, and counsel states, so what is your name?
Yes, sir.
Mr. Yes, it is stated on behalf of Mr. Yes Saul and counsel that his client has taken back the file and it does not have any instruction. You are C.
You are Miss S. Sahu. You are Miss S. Sahu.
Miss Sahu.
So your
Does not have any instructions to press this.
Associate of Mr. G.K. Mahanti.
All right.
He is accordingly.
When did he take the file?
29th July.
4-5 days has gone. 1 date we can do. Miss S. Sahu.
No objection.
No objection to engage any other ground.
So, there's this matter on. 1 week,
Oh, blessed.
let the, all right.
Item 12.
Here also, though there is a delay of 271 days, your lordship had directed that delay will be considered at the stage of admission. Petitioner was appointed as a computer operator, not against any sanctioned vacant post, not through any recruitment process, my lord. However, she approached the learned tribunal, state administrative tribunal, claiming regularization of service. A counter affidavit was filed that there is no sanctioned vacant post. She was never appointed against sanctioned vacant post. So her service cannot be regularized. Then the matter was transferred to this honorable court. And this honorable court, by virtue of a judgment, that is impugned judgment, is at page 80, have directed for regularization of service. Petitioner has rendered 20 years of service. That is the only consideration. But so far as finding whether she was appointed again, that finding is absolutely silent from the entire judgment, although there was a specific submission in the counter affidavit. Now, on T7/2024, your lordship have also directed the other side to examine whether the case of the petitioner, this case is squarely covered by the principle laid down by this honorable court in Ravindra Patnaik case, my lord. That judgment I had also covered because my lords have laid down certain principles for regularization service, the basic requirements. So, if your lordship will have a glance to that judgment. If my lords may have glance to that judgment already supplied. If it is there, I have one extra copy. Lordship, I'm sorry, I have only one copy. Achi. It is there.
It's there. The end of the brief we have.
My lord, may kindly have a glance to para 7.20. 7.20, that is at page 63 of that judgment, my lord. May I place it, my lord?
Yes.
To acquire a right to the post, it is imperative that the appointee is recruited according to law, meaning thereby that number one, he is eligible as per the recruitment rules to offer his candidature for selection and consequent appointment on a post that is appropriately advertised. He is made to face a selection process conducted by the authority constituted therefore. 3. Upon his selection, he is appointed on a duly sanctioned post and thereby confirmed in the service after the period of probation, if any. Then next, para 7.22. Be that as it may, a claim for regularization would arise for consideration if the appointee fulfills 3 conditions. First, he satisfies the eligibility criteria for appointment. Number 2, he has faced a process of selection which, though not illegal, can at best be viewed as irregular. Then 3, despite the sanctioned post on which he could have been appointed on substantive basis is not so appointed. but is engaged either on an ad hoc or casual or temporary basis or even on contract and continues for years together with ill motive to deny him the constitutional statutory safeguards. So here, my lord.
You are reading, sure. Third one.
Third. Now, may I take your lordship to the counter affidavit that was filed before the court below, your lordship. Your lordship may kindly see page 36 of the brief. That is para 21 of the counter affidavit.
Yes.
That in reply to para 6.24 of the OA, it is submitted that she has not been engaged against sanctioned post and her engagement is not as per the recruitment rule. So the regularization of service cannot be effected. This was the specific statement made in the counter affidavit. So far as the findings of the Honorable Single Judge, your lordship may kindly have a glance. That para 6.7 of the impugned order. After referring to, your lordship may kindly take up para 6, that is at internal page 6 of the judgment. Page 6 of the impugned judgment. Having heard the learned counsel for the parties, after going through the materials available on record, it is not disputed that the petitioner is continuing as a computer operator / data entry operator with effect from 1/10/2002. And in the meantime has already completed more than 20 years of engagement on contractual basis. It is also found from the record that monthly wages of the petitioner has been enhanced from time to time, and the petitioner though was initially engaged with monthly remuneration of rupees 4,000, but the same was enhanced from so and so to 9,000 per month now. It is the view of this court that the petitioner, in view of such long continuance, has approved a right in her favor for absorption in regular establishment. Then your lordship, the Honorable Court has referred to different judgments, and the final conclusion is at para 6.7. In view of such continuance of the petitioner for last 20 years and placing reliance of the decision of the Honorable Apex Court as cited supra, this court is of the view that the claim of the petitioner for her absorption in the regular establishment deserves favorable consideration by the opposite parties. Not only that, since the petitioner is continuing for last 20 years, this court is also of the view that the petitioner is continuing as against a substantive vacant post. This findings to the materials available on record. The specific submission made in the counter affidavit that there is no sanctioned vacant post. Even your lordship will find from the original application that was filed before the Honorable, nothing has been mentioned that there is a sanctioned vacant post. She was only engaged on daily wage basis to do some computer jobs as a computer operator, and her service has been utilized. There is no dispute, and for that she has been paid her remuneration. So, in view of the principle laid down by the Honorable Court, so also the submission. That is my submission.
Yes.
May I please? In the last occasion, you also asked me to examine whether the case of Rabindranath Patnaik is covered in your case or not. I have examined, but that is not covered because he is a part-time sweeper. And he must have worked in different places in one day. And he is a part-time sweeper, and he was getting 3,000 rupees, 300 rupees per month. That to my lord. And for half an hour, 1 year per day. But here, my lord, that remains, my lord, Your Lordship will kindly appreciate one thing.
Please come to 6.7
Yes, ma'am.
of the order.
Yes, ma'am.
So how do you say that you were working against a substantive vacant post?
That was not a substantive vacant post, I
Then-
agree, my lord. But the Honorable Single Judge, my lord, the Honorable Single Judge has never said that you regularize his, these services of the petition. Rather, my lord, it was not disposed of once. And at least time the hearing was held and the government officers were called upon to explain why you have been allowed such type of persons for so long time. And that to my lord, here my lord, this when considering all aspect that this opposite party has already rendered for more than 22 years of service, and the Honorable Single Judge has said you take step to regularize so that yes, that is the my lord.
What is the observation?
Yes, observation is there. Observation is there because she has already rendered 22 years of services.
For her absorption in regular establishment deserves favorable consideration.
Madam, that of course there. But finally, what is the order? The order is take step to regularize. That means, my lord, you frame a scheme.
Not only that, since the petitioner is continuing for last 20 years, this
My
court
lord.
is also of the view that petitioner continuing as against sanction in vacant post.
No, my lord.
And take appropriate steps for absorption.
Yes, sir. Take step means, my lord, the government will make a scheme or to see that all the persons case will be considered. That is the intention of the Honorable Single Judge.
If this is your submission, then we record that and we can dispose it
Yes,
of.
that is the observation of the Honorable Single Judge that you frame a scheme or because my lord, the government officers were called upon to appeal and they were there and they said that there are 19 similar 19 persons are continuing since long, and that is the reason why this Honorable Single Judge has said you take step, you make a scheme or whatever it may be. It is not
Government officers were called means personal appearance.
personal, not popular. They were asked to help the government council.
How? On virtual mode?
My lord, the order is there also.
All right, we are disposing it off in terms of what you are saying.
That to my lord, here my lord, apart from that, since your lordship, there is a delay of about 300 days.
We will consider.
That delay point, my lord, that I also want to argue the matter. The delay point, your lordship will see. Here, apart from that, there's the main hearing of the case, my lord, Nihal Singh case has been taken into consideration. Your lordship knows the Nihal Singh, they have said it is the duty of the government to sanction post or not. But if they cannot allow such type of persons to continue forever, I do not make a submission on that line because your lordship knows everything. Nihal Singh case has not been taken into consideration in the Ravindra Patnaik case. As regards the delay, your lordship will find what delay, my lord, I have filed an objection to the condemnation delay petition, my lord. Here, my lord, your lordship will find from the interim application for condemnation delay, they have taken a point I may permit it to place. This is IN number 827. This is an interim application filed by the State Council for State for condemnation delay. They have taken this point, paragraph 4, that after receipt of the above order dated 5/5/2000, my lord, paragraph for 827, sorry, IN number 827 of 2024. My lord, kindly have a glance. This is a application for condemnation of delay. Let me place, my lord. They have said the appellants above named who are functionary of the state Odisha has filed the present inter-court appeal challenging the order dated 5/5/2023 passed by the Honorable Single Judge in WPC such on various grounds. The amendments made in memo of appeal may so answer. Paragraph 4, my lord, that after receipt of the above order dated 5/5/2023, necessary consultations were made with government authorities and the matter was referred to law department views, and the law department on 13/11/2023 given its views to file writ appeal against the order passed by the Honorable Single Judge. Thereafter, the government in its letter dated
23/11/2023 instructed the PCCF Kenduliv, Odisha to file writ appeal, and thereafter the PCCF Odisha on 3/1/2024 authorized the DO for Anugul division to file writ appeal by challenging the said order dated 5/5/2023, and which was filed, my lord, on 1/3/2024. Here, my lord, and even though it has been filed, my lord, the certified copy was not filed, anyhow for that they have filed an application to dispense with the certified copy. So, my lord, now practically it is more, about 300 days delay, even though perhaps the registry has pointed out 271 days delay. In that regard, my lord, I have filed an objection to the interim application, where I have pointed out that I have referred many Supreme Court decisions, and that too, in my objection, if you lordship permit me, I will place my objection, paragraph 4, my lord, I have mentioned. Paragraph 3. Paragraph 3 of my objection I am placing that before giving Parawai's reply in the above mentioned case, it is humbly submitted that this Honorable High Court by its order dated 5/5/2023 disposed of the writ petition WPC number answers filed by the respondent petitioner inter alia, directing the appellants to take appropriate step for absorption of the respondent petitioner in the regular established within a period of 3 months from the date of receipt of this order. That after receipt of the aforesaid order dated 5/5/2023, so by the way, this is the, they have taken that, this is the averments of the State Council, my lord. Paragraph 5, my lord, I have given the reply that as it transpired that the present case not only was there is a delay of almost 271 days in preferring writ petition, but also deliberately delay about 10 months, since in complying the order of the Honorable High Court on the expert pretext of the stand that the delay caused for filing of the memo of appeal is due to observation of the official formalities. Such an explanation ought not be construed as a satisfactory explanation delay. It is further emphasized that due to series of bureaucratic delays and inefficiency, the memo of appeals are being filed that leading to the application delay, so as no need for meritorious claim of the present respondent petitioner. That sufficient cause has not been shown to condone the delay of 300 days in preferring the appeal, and the delay cause for filing of the memo of appeal is due to the observation of the official formalities as alleged, which is not tenable in the eye of law. That the above mentioned application for condonation of delay suffers from delay and laches, since sufficient cause has not been shown to condone the delay of 300 days in preferring appeal. That apart, no due diligence has been indicated in the application in preparing the writ petition on the scope internal application is liable to be set aside as consequently the accompanying writ application is to be dismissed. But I have also referred some of the judgment of the Honorable Supreme Court in paragraph 9 of my objection, and in page 5 of that I have given the citations. The respondent submitted that appeal is able to dismiss on the point of limitation, and the respondent here relies on the following judgments passed by this Honorable High Court as well as the Honorable Supreme Court. That I have given, my lord. Your lordship sitting in a division bench, an identical issue for the self-same reason that official delay, your lordship has dismissed the without condoning the delay. Your lordship's ordered that. Now, apart from that, there are also several orders I am in hand, judgment I am in hand, which will this type of delay your lordship has never entertained. That
We should.
No, that I cannot say. That I cannot say. But your lordship has, here, my lord, if there is a case, your lordship will kindly appreciate one thing. My lord, fact remains this present of respondent has already served for more than 22 years of services. That to my lord, it is, and it was hard for about 15, 16 times. And that to my lord, in case, my lord, now if your lordship today will allow you this writ application, then tomorrow, my lord, I will be nowhere. After rendering 22 years of service, there is no provident fund, nothing.
Despite all the sympathies which we may have for
Minor.
these persons,
Minor.
we must also have sympathy for them who could not get even this.
Sympathy for the state.
Sympathy not for the state, sympathy for those persons who could not get daily wage employment. These persons could get daily wage
Yes,
employment
yes.
because of their proximity with the officials. All right.
If your lordship will
So,
permit.
we do have, we cannot ignore, and we have been ignoring their rights.
Yes.
Like a person favorite to one, A is appointed on daily wage basis. And because A feels that thereafter, after he should be regularized, he was regularized. After having worked for so many years and without realizing and intentionally, may say so,
yes,
that those persons who did not have any connection, any proximity with anyone, he could not get even a daily wage employment. You are talking of regularization. What about them?
I will bow down to your lordship's view, but fact remains your lordship kindly appreciate. Hereby, this is a peculiar case. This is the exception. Why, my lord? Why? Because in the year 2000, number of typist posts are available in Orissa. And of course, and computer introduced. Here, my lord, there were no sanction post, of course, because there was no, this system was not there. The operator computer post were not available. That question doesn't arise at that time. Now, my lord, the state government has taken a decision to abolish the post of typist in different departments and create the post of data entry operator. Here, my lord, in order to manage the forest department, in order to manage, your lordship will find, in order to manage the work, because there are heavy work, because typists were there and typist post, there was no hand. So many the petition, these opposite parties were picked up to manage the work.
Picked up means what?
My lord,
Did the forest officer go to your residence?
No, it might have been, but here, my lord, this is a case because it is not that, or they could have sanctioned the post since last 2 years.
We don't know. Therefore, we are putting this question: that did the Secretary Forest go to your residence to request to please come? The government, the entire machinery of the government.
But here, my lord, in order to manage the work, she was picked up in order to manage the work, because at that point there were data entry operator personnel were not available. Only few persons are there, and they were thereafter, my lord, they were not created any post. That is not in my hand, my lord. Your lordship know the Nihal Singh case is very clear that it is the duty of the government to see to how to create the post, or it is not the hand of the poor employees.
We will deal with Nihal Singh. If Nihal Singh has not been dealt with in that,
I beg your lordship, because in case today your lordship.
No question of sympathy has no role.
No, that's true.
In such matter.
Lordship will go by law, but
Sir,
here also
compassion. We are compassionate always, but
here, my lord, only I pray, my lord, in case my lord kindly visualize the problem of this type of employee. Now, what happened, my lord? They were also not provided with the provident fund benefit, even though she has.
Sir, you have very fairly submitted two things. That it was not a substantive sanction post. The court did not intend to issue a direction that there should be absorption. The court's intention was that the single judges wanted consideration of his.
Yes, exactly.
So we can consider.
But prior to that, my lord, since there is a 300 days
we will
delay.
deal with Mr. Counsel. Since you have raised the objection, we are under obligation to deal with that. We'll deal with that.
My lord, kindly consider all the aspects, because
we'll deal with, because we have so much. Laid so much emphasis on limitation, we will deal with third result of limitation. Okay. Yeah.
Item 13.
The question of limitation.
My senior has referred to several judgment and intra-departmental question has been raised. So entire thing has been answered by the Honorable Apex Court in 2023 judgment of Shivraj Singh.
Is that judgment we have taken note of in one of the
Yes.
Shivraj
cases?
Singh case also said what is the
We have,
merit of the case also
we
is to
have-
be adjudicated.
we have considered in one of the cases.
Para 41 of the judgment entirely.
No, Shivraj Singh, we take the solution.
And we will ask them to pay some money also.
Money will not do because he has already rendered 24 years, by this year, 22 years have already been passed. And as soon as your lordship will going allow this writ application, tomorrow, my lord, this lady will be nowhere. That is up to my lord's consideration. That cost will not suffice.
Item 13, your lordship.
That we can direct that
My-
she should be allowed to continue. If there is any pause, then she should be allowed to continue. No question of permanent.
Absolutely regulation, but the lordship may, at least the government must make some principle policy.
All right.
That part is to be reflected.
Item note 13.
Item number 13, kindly taken up next week, my lord. I need more preparation. Kindly taken up next week, my lord.
As requested.
Item 14.
In item 14, the lordship has imposed cost of rupees 15,000. I have already paid.
Yesterday, that remitted to my account, but that copy was not given me to the.
I'm sorry, just
Copy of what?
read appeal is.
Your lordship.
Writ
directed
appeal.
my-
I'm sorry.
Get that. Get that.
This is-
Then council also accepts notice on behalf of the he seeks adjournment. You want to see that?
My lord, pardon.
What do you want?
Next week.
No, after 2 weeks, after 1 week, your lordship.
Request adjournment till 2 weeks. Most of with this case on.
And also cost he has received that
We is
15,000.
an noted fact that the petitioner has received the of rupees 15,000, which was condition precedent for condonation of delay.
That since the petitioner is, this one is out of employment, lordship may fix it that.
Did it there?
Item 15.
Please, your lordship. Your lord, if your lordship will see the IA numbers 5683/2024 is at flag B for amendment of cost enter. Lord, what has happened that the private respondent, my lord, meanwhile died and I have substituted the legal representative of private respondent. And my learned friend is appearing for party. So far as the matter is concerned, my lord, identical matters have been, my lord, tagged and it has been adjourned to 13th of August for hearing, and this was the order passed in the
This is regarding what?
regularization of daily wages.
Yes.
The impugn order, if your lordship. No notice, my lord.
Notice.
They have
you are
already.
appearing.
Already appeared.
Issue notice. You would like to accept notice on behalf of the respondents. Of IA number, middle of the application. Same on the state.
Item number 17.
Maybe. Here the appeal against the interim order. Honorable Judge dated 21st June 21, my lord. The petitioner is the appellant, my lord, who is petitioner, who was a candidate for the post of constable in CRPF, my lord. After his selection, he was declared unfit for medical unfit, my lord. As per rule, I made an appeal, prepared an appeal by obtaining a certificate from the SC Medical College by the specialist, my lord. Despite that, they did not accept it. I approached the Honorable Court in the writ petition, my lord. The Honorable Single Judge, by order dated 2/4/24, page 19, my lord, directed for examination by AIMS, by a constitutional board, AIMS Bhubaneswar. And AIMS Bhubaneswar also gave a report, my lord, in my favor. He is fit for the job.
He is fit for?
My lord?
He is fit for the job.
Yes, madam.
How AIMS can say?
AIMS, my lord, they have declared unfit for a hypospadias. For hypospadias. That is a urological defect, my lord. Urological defect.
Mr. AIMS can say
yes,
that he is fit. He does not have any ailment.
Yes, ma'am. That is the.
But the AIMS cannot say that he is fit for the job.
AIMS say he is
the job they will decide.
No. Yes, ma'am. AIMS said, my lord, the report of the AIMS, my lord.
Where is that?
At page 24 and 25.
Yes.
24 and 25.
Yes.
The,
24, annexure. What is annexure 5?
Yes, ma'am. Annexure 8, my lord. I have obtained certified copy from this. The report was submitted by a seal cover, my lord. I obtained a certified copy. And examination was made in 25, my lord. The examination report, my lord. Page 25.
So what is final single judge?
This report, Honorable Single Judge sent for the medical report. Now the Honorable Single Judge again sending to be further examined by the Army Hospital.
And you are challenging that order?
My lord, two reports and me favor, my lord. SC Medical College report and also.
These are frivolous appeals. Your writ petition is pending. And you are challenging the interlocutory order.
Yes, ma'am.
So let the writ petition be decided. You are obstructing decision.
No,
disposal of the writ petition.
Now,
Army hospital, my lord, orders like this.
Army Hospital is not there in Odisha, my lord. Army Hospital is a Calcutta. He is a poor man. He cannot go to Calcutta, my lord.
We'll give him money. All right. Send him to our chamber. Send him to my chamber. I'll give him money from going to Calcutta. How can you?
Almost this single judge sent it to AIMS give a paper in my.
No, AIMS, my lord, AIMS said that he is medically bound. Thereafter, under treatment, after treatment, he is saying that he is fit for job.
This is an interlocutory order. The matter is pending. This is not the way in which the intra-court appeals are entertained. The intra-court appeal has been preferred against and dated. Your interim order dated?
21st June 24, my lord. Page 36.
21/6/2024 passed in WPC number 26844 of 2020. Stop. Next, we are not delineating the facts. We are not inclined to entertain this intra-court appeal against an interim order, as the said interim does not amount to denying or granting final relief as sought in the proceeding.
This appeal is accordingly dismissed. Let WPC number so and so be placed before appropriate bench having the roster. Yes.
Item number 8.
Please, my lords. Lords, item 18, kind attention.
18.
Please, my lords. May I draw the kind attention of the Honorable Court? I am appearing for the appellant, my lords.
Yes.
My lords, in this case, the learned single judge has granted the relief to the petitioner, respondent number 1 and 2, in total disregard of the present law, which is as on date. And a substantive relief has been granted to the opposite party.
So this is against an interim order.
No, it is against the final order, my lords. The final order, it is by way of at page, my lords, may kindly have page 14. The learned single judge has disposed of the writ petition.
18. I don't know. 18. Yes, what is the reality?
Please, my lords. My lords, the infirmity in the order is that the learned judge has totally disregarded the law as on date it exists, and the learned single judge has granted relief.
The law which exists.
Please, my lords, may kindly see the issue before the learned single judge was whether in a life insurance policy the proceeds of the death benefit are to be given to the legal heirs or to the nominee. So, my lord, this was the issue before the learned single judge, and my lord, learned single judge, relying upon the judgment of Sarvati Devi, which was passed way back in the year 1983, when the amendment in the statute was not there. So he has referred to that judgment and has granted the relief. My lords, whereas in the year 2015, the Insurance Act 1938 was amended, and a beneficial interest and title was conferred on a limited number of nominees. My lords, may kindly for a minute have the provisions of amended Act 1938, Insurance Act, section 39, 7. Merge up to 6, the act is same. The legislature, with this amendment, introduced section 7 to 11. My lord would for a minute have, subject to the, my lord is having the copies.
We are trying to have.
Please, my lords. My lords, may kindly refer to 39, 7, subclause 7. May I read, my lords?
Yes.
Please, my lords. Up to 6, there is no substantial change, and 7 is the new provision which has been introduced, subject to the other provisions of this section, where the holder of a policy of insurance on his own life nominates his parent.
Where are we?
I am reading clause 7 of section 39.
Yes.
Clause 7, my lords.
Yes.
Subject to other provisions of this act. My lord is there.
Yes.
Where the holder of a policy of insurance on his own life nominates his parents or his spouse or his children or his spouse and children or any of them. The nominee or nominees shall be beneficially entitled to the amount payable by the insurer to him or them under subsection 6, unless it is proved that the holder of the policy, having regard to the nature of his title to the policy, could not have conferred any such beneficial title on the nominee. And my lords, further, my lords, I may read section 8 also. Section 8 says that in case the nominee also dies, before but taking the amount or the beneficial amount which he is entitled, then in that case also the legal heirs of the nominees would be entitled to that amount and not the legal heirs of the deceased policy holder.
Now, where are we reading?
Clause 8. Subject as aforesaid where the nominee, or if there are more nominees than one, a nominee or nominees to whom subsection 7 applies, die after the person whose life is insured, but before the amount secured by the policy is paid. The amount secured by the policy, or so much of the amount secured by the policy as represents the share of the nominee or nominees so dying, as the case may be, shall be payable to the heirs or legal representatives of the nominee or nominees.
What is the decision in case of Sarvati?
Please, Maharaj, Sarvati Devi says that the nominee is only an agent. Nominee is only the hand which receives the benefits, and he is under an obligation to distribute.
Mr. Counsel and single judge has relied on that decision. What is wrong in that?
Because that is wrong, because that judgment is no longer holds the field. Why? Because section 7 was not there at that time. But the legislature has in its wisdom introduced section 7 to 11 later on in the year by way of amendment in the year 2015. So because this was felt by the legislature,
So,
that
Sir, when was this, when had this policy started?
Yes, my lords. My lords, the
So
policy
whether
had
the 2015 will apply or the previous
No.
law will apply?
Yes. Now I'm coming to the facts. The deceased lady, she was a working lady. She was married to the respondent number 1, and she was having a daughter also. And she took the policy. She was married in the year 2016. She took the policy in the year 2017. That is August.
Just a
Please, my lords.
According to you, the policy was subsequent to coming into force of subsection 7 to section
11.
This is contention.
Yes. This is my contention, and it is borne out. This is not disputed facts. Facts are not disputed, my lords, that the policy was taken in the August 2017. She continued successfully for 6 years. Then, because of cancer, she passed away. And in the nomination policy, nominee was made her mother. Sole nominee was the mother.
Yes, who is for the other? Someone is there.
So, let's make kindly listen.
Someone appearing.
Yes, we are appearing.
Just a minute.
Now,
yes, he appears to be right, Mr.
My lords, I'll just explain, my lords. This issue regarding this section 39 in its amendment is now this is being considered by various high courts. Now, Madras High Court has decided in favor, the same view which the Honorable Single Judge has taken. Now, if your lordships would see this judgment, somehow the Honorable Single Judge missed.
My lords, judgments.
This is a contentious issue.
Mr. Please don't do this.
Okay, ma. Sorry, I'm
just giving 2 copies. This my learned friend might be aware. This is 2024 4 SCC 642. Now this conflict arose from in various high courts. These conflicts are coming up. Now this is what the Supreme Court says.
Yes.
The judgment 2024 4 SCC 642. This, I think this was because the single judge also, he might be aware of this judgment.
No, but we have to address,
my lords,
based on this act, Insurance Act, no other act.
So this judgment, while discussing Companies Act and how share securities are to be given, also discusses about Insurance Act. So maybe it is an obiter, but
yes.
That is what I was trying to show, my lords. Straight away, my lord may see para 40.
Let us see.
I bow down to your lordship. This is an issue which requires the consideration of various high courts. But what I was trying to submit is, if my lord would see para 40 at page 660 on the left-hand side,
Yes.
the heading, my lords, is various legislations. I have given a copy for my Lord Justice Rath also. Legislations. This is for the share securities under the Companies Act, but they discuss also about the Insurance Act 1938.
Yes.
Now, my lord may kindly see para 40 I'm just placing. In an illuminating list of precedents, this court as well as several high courts have dealt with the concept of nomination under legislations like Government Savings Certificate Act 1959, the Banking Regulation Act 1949, the Life Insurance Act 1939, Quare Insurance Act 1938, and the Employees Provident Fund and Miscellaneous Provisions Act 1952. It would be apposite to refer to what the court said on nomination in reference to these legislations. Then the table is given. Here, my lord may kindly see Sarbati Devi is the first one. I'm reading from page 661 on the right hand side. Sarbati Devi, the table says what is held. Nomination under section 39 of the Insurance Act 1938 is subject to the claim of the heirs of the assured under the law of succession. Then under EPF and MPF Act, Nozer Gustad have said what it holds. Accordingly, various 4 legislations they have held, including the Banking Regulation Act. Then para 41 would be important. A consistent view appears to have been taken by the courts while interpreting the related provisions of nomination under different statutes. It is clear from the referred judgments that the nomination so made would not lead to the nominee attaining absolute title over the subject property for which such nomination was made. In other words, the usual mode of succession is not to be impacted by such nomination. The legal heirs, therefore, have not been excluded by virtue of nomination. Then 42 also refers to Insurance Act 1939, para 42. And basically, they have gone on to hold that the normal procedure is that a nominee is just a custodian of the money. It has to go as per the law of succession. Now, my learned friend is right. This amendment came about. Now, the Law Commission in its recommendations wanted a number of amendments, including while making an insurance policy, you have to have 2 categories. You have to select the collector nominee and the beneficial nominee. But somehow all those recommendations were not accepted. Just a few of them were accepted. So now this 39(7), now for your lordships to differ with these paragraphs and subsequent paragraphs.
We shall not differ.
My lords, this may be obiter. Para 44 also is obiter.
Para 40, in fact, when the Supreme Court refers to the Sarbati,
my lords,
it refers to the law which was existing prior to. Cannot ignore the law.
My lords.
The law has not been let down in view in terms of subsection 7 and other.
I bow down to that. This judgment doesn't analyze 39(7). What the Madras High Court has done is followed Sarbati Devi and analyzed 39(7) and has somehow said that the same law would govern. It is because one of the recommendations of the Law Commission was that if the nominee gets absolute rights, as in this case, because here the dispute is between the mother and the daughter for the 4.5-year-old daughter. So if the mother gets, that means the dispute is between the grandmother and the daughter.
We are not on the facts. We are on the consequence of the provision. Nomination here, it's a kind of will that after I die, the amount will go to A or B or C. So had it been a case where the policy was off prior to 2015, the matter would have been different. But just think of this situation that after 2015, he appoints someone nominee. We must presume that he was knowing.
Well, in fact, I bow down to what falls from my lordship. Here, this is something which the courts have to analyze. 39(7) has not been analyzed. Now, the Supreme, then I was on, in fact, while reading this yesterday, I was thinking that this judgment has come about in 2023. So while laying down this, they have probably not considered 39(7) because they do mention Insurance Act. So this is somewhat similar to the 29 capital A which your lordship is dealing. So I am just banking on that.
No, in fact, there is difference between 29.
The 29A Meghalaya, if my lord see the Meghalaya High Court judgment, that was on a different footing, but then the judgment has come about. I as a lawyer can say that to your lordships, the judgment is on a standalone basis is somewhat different. But if my lord sees the Meghalaya High Court judgment, then it's on a different footing. But that all that I want to say, my lords, is these paragraphs would be something which your lordships will have to deal.
So it is good that we shall clarify on section 39.
My lord, in fact, what I would suggest, my lord may, if your lordship is a, because ultimately the writ petition has been dismissed. No relief has been granted to my clients. We have been relegated to the common law forum.
You have not been relegated. You have been relegated only for the purpose of succession. Otherwise, the relief has been granted.
My lords, to that extent, now in succession certificate, this dispute is something which probably will not, because other courts are also dealing with this. Bombay is dealing with this. Madras, there is a judgment in our favor. So if your lordships would entertain this.
We do not find any in the language
of 39.
Of 39. We do not find it to be a complex question of.
It was clarified it very clearly.
Because the language would be even in the Banking Regulation Act, because this dispute has now, why did the Law Commission make these recommendations? Unfortunately, I have not got all of them. Even the Banking Regulation Act, because the best case scenario is under the Banking Regulation Act. There also the courts have leaned in favor of the legal heirs. So across the board, they are always leaning in favor of the legal heirs.
See, therefore, particularly in the matter of insurance,
my lords,
the legislation draws distinction. It may be intentional.
Well, that is something which. So may I suggest the lordship?
We gather intention on the basis of language. So
I'll assist your lordships in this. Your lordship may entertain the writ.
All right. So
is it the first date?
This is the first date. We are appearing.
We accept notice that.
May I suggest one thing, madams, for benefit of both? The amount is now with the insurance company. We will not, none of them, either the appellants will not get, we will not get interest on this. So let the amount be kept in deposit with an interest bearing account, because otherwise for this entire career of this case.
No, we will hear and we will finalize it in 2 weeks, Mr. Ashra. 2 weeks we can.
Till then, my lords, the impugned order may kindly be stayed, my lords. Till then, because.
Please, get it.
The insurance company, because this is a matter of policy governing the entire.
Someone is appearing.
No, my lord has to notice that.
No, but who was appearing?
My lord may permit Dusty, if they are allowed, they can serve it on the same.
Whether there is any standing counsel for which insurance company is this?
ICICI.
ICICI Prudential
Life Insurance.
ICICI, I think Mr. Datta appears usually. ICICI or Mr. Adam Ali Khan?
ICICI
Prudential.
Mr. Rajit Rai appears.
Rajit Rai.
My lord may issue notice.
No,
They have a panel.
Then we can dispose it on.
No, if he is willing to accept.
Tomorrow we can take up Mr. Mishra.
Serve a copy.
Tomorrow we can take up the matter. In the meanwhile, if
my friend can
inform him.
He was there in court today. I don't know if he's still there.
Tomorrow
counsel, they were represented. They have filed counters. Same counsel they can serve.
So that was Mr. Rai? Who was the counsel?
My friend is not able to tell the name.
Is Mr. Paresh?
And yes, I am Mr. Parashar, my lords.
No, you are there for the opposite party, private opposite party. Opposite party to Mr. N. Mahanti.
My lords, may I submit one thing, my lords?
Tomorrow. Within first 5 cases. Learned counsel appearing on behalf of the
petitioner shall be at liberty to serve a copy of the memo of appeal on learned counsel who represents what is the ICICI?
ICICI Prudential.
My lord, respondent.
My lords, on the given, my lords, may I say one thing? On the given email ID, my lords.
With a request to him to be present when the matter is taken up tomorrow.
Item number 19.
Mr. Parashar, it will be taken up tomorrow.
Please, my lords, much obliged.
Yes.
Much obliged.
19, Lord, on behalf of me, can I taken up 2 weeks after, Lord? On behalf of Mr. Can I taken up 2 weeks after, Lord? Because, Lord, his elder brother has been expert, Lord. He has gone.
All right,
Grateful to you.
as requested, 2 weeks.
Item 20.
And in item 20, the petitioners who was accepted for the tender for construction of a daycare center at Govinda Block, Tenkanal, which is annexed as Annexure 1, page 6, my lord. Subsequently, he was provided work order, but no work site was stated in that. And in Annexure 3, my lord, in the second line, interested to Sachin Sahu B, contractor with date of commencement and date of completion as 6/12/2023 and 5/6/24. Date of completion is 5/6/24 respectively, but the contractor could not start the work as the site has not been handed over till date. The contractor, being aggrieved with delay, has stated his willingness for closure of the contract. Lord,
So what do you want?
My lord, I have approached them for termination of this contract, but they are not willing for termination or return of my bank guarantee. Termination of contract or return of my bank guarantee. Since the period that is starting from 6/12/2023 to 5/6/24, they have not yet provided any site.
File affidavit.
File it.
8 weeks. 8 weeks time is allowed for when the AGA receives instructions. File counter affidavit.
Item 21.
May I please, your lordship? My lord, the cancellation of tender of the petitioner, my lord. Here the annexure 1 at page 16 thereof. Tender call notice was issued in respect of 3 bridge. Your lord, may kindly see page 16, my lord.
Single tender, my lord.
My lord, it is not cancelled on the ground that it is a single tender, but it is cancelled. The single tender's amount is more than 1% in excess. On that ground, it is cancelled. Whereas, in respect of the other tender,
Where is the instruction?
Instruction.
You brought the decision.
My lord, that is a single. Lordship, that is Annexure 7, my lord. Annexure 7, it is stated as single tender, my lord. Page 68, my lord. Lordship, kindly see.
that is not the.
Page 68, Lordship, kindly see. Annexure 7, my lord. This is a letter of financial FA, my lord, to the chief engineer, my lord.
See, this is the judgment which is applied.
My submission, my lord, my tender has been cancelled on the ground that single tender is 1% excess. But on the same tender call notice, my lord, your lordship may kindly see Annexure 7.
See, have you seen this decision of this court?
No, my lord, I have not seen.
Read paragraph 10 and make your submissions.
No, my lord, I am not on that.
You are not on that, but we are on that.
No, my lord, I am, your lordship, I will see that, my lord, then I will submit, my lord. But fact remains, my lord, on that very tender call notice, 2 breaches are there.
one has been accepted, single tender at excess of 1.5. That's why I'm submitting, your lordship may kindly see annexure 11 to my additional affidavit, my lord.
Yes.
Page 7. There, on the same day, evaluation was
Mr.
made.
Counsel, you are very confident of your case. You are so emphatic on your submissions.
My lord, I am obliged, my lord, but my submission is they cannot take two stand on the same tender call notice.
They can. They can do a stand can two stands. If that matter comes to us, we will decide accordingly. If this matter when this matter is there, we are deciding this matter, this case.
And then I will see that citation. Then
just read a paragraph, small paragraph.
my lord, I have gone through the facts and other
No
things.
fact, no.
But my submission, it is not.
Your submission is clear.
But Annex 11 doesn't show it as a single tender?
Yes, my lord.
Well-
My lord, I have seen this. Your lordship may kindly see annexure 11, page 7, 8.
Yes.
Your lordship may kindly turn to page 8.
Okay.
Bottom, my lord. One qualified. Page 8, my lord. Then your lordship may kindly turn to page 9.
One moment. Two bidders.
My lord.
Page 80 orders.
One is disqualified, another is qualified. Bottom, my lord.
Just one moment.
Bottom towards right hand side. Then next page, your lordship may kindly see annexure 12. It has been accepted at 1.5% excess. Page 12, my lord, annexure 9. Same authority, my lord. Same type of bridge.
Challenge that. Ask someone to challenge.
My lord, here by the annexure 12, my lord, the estimated cost was 6 crore 94 lakhs 42,242. It has been accepted at a cost of rupees 7 crores 4 lakhs 83,876, which is in excess of 1.5%, my lord. My same authority, my lord. And the same day evaluation was made.
No, I have to take instruction, my lord, whether that is a retender or subsequent tender, my lord. Even if lordship kindly see paragraph 9, my lord, of this judgment. The same question arose in this judgment also. Now, this honorable court stated that if it is contrary to the OPW code, my lord.
This case, if I remember, it first was unresponsive, thereafter second tender, so that is why it was not considered to be a single tender at the first instance.
And second tender,
to
my lord,
stick
even
with
if the
the
second tender, my lord, it has to taken permission from the government, my lord. That is the OPW code, my lord.
That's the code.
My lord, lordship kindly see paragraph 9 of this judgment.
It's not, we have also dealt with another case
Ma'am.
with that, where he had come up saying second tender, like it was actually the first tender.
My lord.
And that note doesn't say that you have to give it to him. It says, in case you give it to him, you have to take permission of the
My
higher
lord, my
authority.
lord.
No, but he's pointing out that
Ma'am.
both are in the similar footing. How have you given?
No,
it
lord,
to
this is not
somebody
the
else?
similar. Only here is that they have decided to open the financial bid, my lord.
There's the agreement thereafter. Right?
My lord, nothing is there, my lord.
Page 9, my lord, and
Lordship kindly see page 9.
Get instructions.
has been asked to execute the
Nothing is
agreement.
there.
Just a minute.
Yes, yes.
Where, how do you say that the agreement has been entered in the second case?
Page,
In the other case?
page 9, my lord, annexure 12. Your lordship may kindly see that.
Page 9, annexure 12. No, bottom of that annexure, they
My lord.
said that committee has decided
They declare to open the
for
financial bid, my lord.
My lord.
That's all.
But
That's all.
he has been asked to execute the agreement by this, my lord.
Where is
Where
that?
have you stated?
My lord, that though in my affidavit I have
If
stated,
it
but
was the single tender, you could not have opened the financial bid.
No, what is the situation, my lord? I have not taken instruction. As per his affidavit, my lord, by meeting, my lord.
but here, my lord, my tender has not been cancelled yet because it is a single tender. But
Mr.
even though
Thompson,
single tender is in excess,
That is one of the grounds.
All right.
and I have been asked for negotiation.
All right, you want court's order for cancellation of tender on that ground? We will direct.
But my
Why are you repeatedly saying
No,
this,
my lord,
as if we don't understand the basics?
no, my lord, my submission is after this, my lord, I have submitted my bid.
My lord,
at
even if the
3 point
negative
less.
equality, my lord. Even if the negative equality, he cannot get the benefit.
This is your
Negative equality, my lord.
This is your submission that your tender not cancelled because it being a single tender.
My lord.
But because you had quoted more price than this is your submission.
My lord.
1% or something. More than
1%,
that.
yes, yes, my lord.
All right. So we shall say that because it was a single tender, it ought to have been cancelled. We
My
shall record that.
my
But my submission on that,
Not my submission.
yeah, Lordship, again, after their letter to further negotiation, I have submitted it is less than 3% less, my lord. That should have been considered, my lord. That may be considered.
Have they given you a letter?
Yes, my lord, yes. That is why,
Giving.
my lord, page 70, annexure 9.
Is that if the tender has been cancelled on the
No.
ground. File your affidavit. 4 weeks time is allowed for the state to file counter affidavit stating the circumstance in which, whereas the petitioner's tender has been cancelled on the ground of the same being single tender, comma, in the other case. नहीं नहीं उसी हो गया सिंगल tender, whereas in similar circumstance in another transaction, comma, financial bid has been directed to be opened. So this case on 4 weeks when the counter affidavit must be filed.
But may I pray, my lord? I have filed an interim application for stay of fresh tender.
I number so and so has been filed for stay of fresh tender. So this application is rejected for the reason that
Let it lie over, my lord,
we are
please.
prima facie satisfied that the petitioner's tender has rightly been cancelled on the ground of the same being single tender.
my blessed.
Item note 23.
This is what you want.
Relating to my lords, release to the royalty, my lords. Similar matters, my lord. Having picked to 12 September, my lords.
Which matter?
3181 of 2023, my lords.
What is that?
GST on royalty, my lords.
GST on royalty?
Yes, my lords.
Can we prepone?
Your Lordship, I have already given a list, Your Lordship.
Can we prepone those cases?
Your Lordship, I am ready so far as department is concerned, Your Lordship.
No, whether they will have any objection to that.
Which date is it posted to?
12th September. My Lord has fixed 8 weeks after that date has been fixed on 12th September.
All right.
Yes.
So do you have any objection if if your application is disposed of in terms of the Supreme Court's decision?
Let that be tagged with
No, we are going to tag your case also, but just we want to know the approach of the bar. We intend to get all the matters listed for to be mentioned.
this one.
And then we will decide whether to prepone the date or not.
Your Lordship, actually, your Lordship, there are two issues. The first one is so far as the levy is concerned, whether GST, whether royalty is a tax or not, whether GST can be levied on the tax or not. The second issue they are placing, your Lordship, so far as for a limited period, the GST has been implemented, your Lordship, 1/7/2017. 1/7/2017 to 31st December 2018. We have levied it at the rate of 18%. The petitioner's grievance in for that limited period, that should have been levied at the rate of 5%. So that is another dispute.
5%.
So these two disputes are there only from 1/7/2017 to 31st December 2018. After that, they have no grievance. That 18% is substantiated. So these two issues are there. So the first issue, so far as the levy, now it has already been decided by the Honorable Nine Judge Bench that it is not a tax. So tax is to be levied, and that those matters, so after 31st 12/2018, those matters can be disposed of without going into the merit of the case by following your Lordship.
So what is your stand on that? Whether 5% or...
Your Lordship, that I'll argue.
No, you may argue, but you must be knowing what you are going to argue.
Your Lordship, in fact, there are 2-3 notifications. As an officer of the court, if your Lordship will ask
As an officer of the court, you must be here.
then your Lordship, it may be 5%. It may be 5% because that cannot be retrospective. But on behalf of the department, I have to argue.
So you mean to say the batch of cases without argument, one set can be disposed beyond that date?
31st 12/2018, all these cases can be disposed of.
Oh.
Gratefully.
So just give us that also as to how many cases are 100% covered by the Supreme Court's decision, and in how many of such cases we are required to deal with that aspect.
5% share.
Your Lordship.
All right.
Your Lordship.
So whether all these are required, taking into account that 5% or...
No, your Lordship. No, your Lordship. Some of the cases are there, which are 1920, 2021 period. Those cases can be disposed of. Out of these 4 cases, 2 cases can be disposed of, and 2 cases have to be.
Please let us know on the date when the matters are listed for.
Your Lordship, without prejudice, I'll
make it. It can be listed any day.
So you prepare the list.
Your Lordship.
Don't wait till prepare the list.
Your Lordship, I'll prepare and I'll.
You wanted to say something.
Your Lordship, but that 5%, 18%.
No,
that will
not
argue.
be.
Your Lordship, I will permit it to argue. Gratefully.
We will take the responsibility.
Your Lordship. Obliged.
Thank you very much.
Item number 25.
page 18, annexure 1 is the impugn order, by virtue of which the lordship will see Sans any regions, they have cancelled the whole tender process. Sans any regions, without assigning any regions, the authorities have cancelled the entire tender process.
So they can cancel. They can do it.
But there is, of course, they can cancel, but there has to be at least one word reason, because these are the matters which I was previously litigating. My client was litigating before this honorable court. Got an order for consideration representation. They rejected my representation that I challenged before this honorable court, referring to that APCON's judgment since the other bidders were not made parties. He had to withdraw it for the purpose of impleading them as parties. So it is at this juncture, even prior to the second matter fight, they cancelled it. But my humble submission would be they should.
So they got rid of so many litigation.
They got rid of. But there is also one more issue which may go against me. There is also one more issue which may go against me. That will be benefit of having a fair senior counsel. But if your lordship see, they say that the period of 1 year, the whole tender was for a period of 1 year, and that period is also in the meantime over. So in any way of the matter.
Why was it withdrawn, Mr. Rath?
Yes.
Why was the earlier writ petition withdrawn?
Because the other bidders were not implemented as parties.
So it was.
APCON's Silpi says to implement them as parties. APCON says they are not to be implemented as parties. There is a conflicting view by the Supreme Court on that issue. So like, without joining issue, now that the period of the whole tender is over, there will be nothing remain to be decided in the matter.
Senior counsel appearing on behalf of the petitioner has very clearly submitted that with the influx of time, the efficacy of the present writ application questioning the decision of the opposite parties to cancel the tender has become infectious. Can we proceed? All right, this application stands dismissed as having become infectious.
Item 27.
May I plead? The petition that is the private opposite parties have encroached the Pani Nala oblique Gocho, that is government canal minor.
Where?
That is Basudepur Bachada village in Bhadrak district minor.
Invoke that Trinath Panda judgment.
Yes.
But you are a college. You are a college.
No, college. Water minor, that is canal minor.
Oh, who are you?
That is the.
It is item 27. Sorry.
So apply that law, Trinath Panda.
My lord, due to the blockage of the canal, my lord, the sea flow water has not.
See, because of this only, we have written a long order. You can follow that. All right. See, if we ask you to file a representation and for them to dispose of your representation, that will be an exercise without any utility. So there is a judgment, you just follow.
But the person filed the representation and also filed.
No file representation there in your Trinath Panda. There is judgment, please examine.
Yes, in this case also will find there was a previous writ application. Contempt order was complied with, and thereafter contempt was dropped. Now my friend says further, Trinath Panda can not come to his aid, he can make an application.
You think they've again done it or what?
Yes, but they say that still the encroachment is there.
My lord, the order of this honorable court, my lord, that is page, my lord.
Trinath Panda.
Page, my lord, that is 2, my lord. That is page, my lord. 32, my lord.
Without looking at the page, you tell us what has happened.
My lord, that is the content petition. This honorable court has direct.
Contempt petition, the honorable court directed for removal of the encroachment.
My lord, but they are partly complied, my lord.
All right.
The order of this one will go, the part will comply.
All right, all right.
See, no order is required of this honorable court for removal of encroachment. That can be done by the executive magistrate. Let him do it. That is the mandate of law, and that is what we have declared in that decision.
Okay, my lord.
Make a mention for item number 32. It's a tender matter. It's some urgency taken up tomorrow, my lord.
Tomorrow it should be taken up, and if
Well,
it is not to be
it's,
taken up, then make a mention.
Well,
Well,
sir,
it's, I was
Senior Advocate
requesting-
Krishnan Venugopal is mentioned that.
Yes.
Well, I was only requesting if it could be a little high on board so that we could place it before my lords.
We will take up tomorrow. That much we can assure.
Very well, my lords. Very well. Most grateful.
49 and 51. 49 and 51. 49 and 51. 49.
Want them to go down? What? Yes, who is appearing in person? Why? What was your item? 29. 29 was called.
Just two matters.
What is your matter?
Sir, matter is one tender was invited by the opposite party, collector cum COSDC Moirvans, and subsequent party in that tender, and also supply order was also issued to me, instructing 4 points in supply order that the quotation was approved by the opposite party, and instruction was given to initiate the production.
What
of
is
the
your
document.
grievance?
Sir?
What is your grievance?
My grievance is after the approval of the script by the export member SDC, the opposite party did not approving the script or neither cancelling the script.
All right. File your
29
4 weeks.
Item 29.
Item 30.
It will come after 4 weeks. In the meanwhile, they will file counter.
Item 30 में kindly take up tomorrow.
Well, try.
Lord, by permitted.
I also prefer more.
In fact, we intend to take up all the matters, but every day we fail. What can be done?
Like permitted item 34 complied, already content may be dropped, already complied, my lord. Item 34, your lord.
31, 34.
34.
Yes, lord. Complied, your lord.
All the magic payment.
My lords, item 31, my lords. Can it be tomorrow? 31, my lords.
36, control matter, kindly call the matter tomorrow. 36, kindly call the matter tomorrow.